of an urgent writ appeal, my lord, for tomorrow. We have filed it on Saturday, my lord. The subject matter of the writ appeal is extremely urgent, my lord, because it relates to the settlement of a fishery. The appellant is presently running the fishery, my lord. But by the impugned judgment and order dated, my lord, 17/12/2023, the private respondent has been allowed to run the fishery, my lord. Whereas, my lord, in earlier round of settlement, he has been declared ineligible, my lord. So, without determining the eligibility of the respondent number 4, my lord, he has been now allowed to run the fishery. I pray for listing tomorrow, my lord, because at any moment the petitioner may be ousted from the oblige, my lord.
May I please, Your Lordship? I beg to mention item number 20, Lordship.
20.
Item number 20, Lordship. In this case, we will file one objection today itself, Lordship. Let the matter pass over for the day.
Yeah.
Yeah, Lordship.
No, wait for your turn. Wait for your turn.
I am petitioner in the writ petition, but
That's
in
why
the-
you wait for your turn.
Lordship.
I'll give you the time. I'll give you the time.
Lordship.
May it please, Your Lordship.
Yes.
Lordship, I pray for listing of a writ appeal, Lordship, tomorrow, Lordship. It was filed on 16th of December, Lordship.
What is the urgency?
Urgency, Lordship, I am replaced by an unqualified teacher, Lordship, that is Abel, Lordship. That order was put to
You've already been replaced.
not replaced, Lordship. The order is passed on 12th of December, Lordship. Till there, I am not handing over the charge, Lordship.
Okay.
Tomorrow, Lordship. Oblige, Lordship.
Me, your lordship. I have government of Assam has filed an interlocutory application, lordship, on 13/12/2023, but it is yet to be listed. Lordship, may kindly take up the
IA for
vacation by stay order, my lord. In writ appeal number 287/2023, there are a series of writ appeal pending before this honorable court, my lord. This matter may be taken along with that matter, but kindly the IA may be listed tomorrow, my lord. I'm deeply obliged, lordship.
May I please, Your Lordship? I beg to mention item number 16 of today's list, Lordship. Lordship, in this matter, Lordship, one more additional activity is required to be filed by the petitioner, Lordship. So, Lordship, may kindly fix the matter after vacation, Lordship.
yeah, D. Buyan.
My lord, D. Bhuya, my lord.
On request made by D. Buyan. No, counsel for the appellant. List on 22nd.
After Lordship, due vacation, Lordship,
That's why 22nd
22nd January,
January.
Lordship. Highly obliged, Lordship.
May I please, Your Lordship. Lordship, with the prior consent of the other side, I would beg to mention item number 17, my lord. My lord, there is some difficulty on our part today, my lord. I'll pray for an adjournment for the same, my lord.
Yeah, for
My lord, I am for the sole respondent. Item number 17, my lord.
have you informed the petitioner's counsel?
Yes, my lord, we have taken consent for the
On request made by Mr.
PH Core, my lord.
P.H. Learned counsel for the sole respondent. When?
My lord, after the Bihu break, my lord.
Okay. List on 24th January.
Oblige, my lord.
Item 1 for motion.
May I please?
Yes.
In this case, my lord, the respondent number 3 and 4, my lord requested the respondent number 1 and 2 to furnish the necessary instruction because this case is related to my lord municipal board, and they have contacted me now. My lord, lordship may kindly give some time to file affidavit. Affidavit is almost ready, my lord.
My lord, notice was not issued in this case, my lord. So if
But, my lord, this can be, my lord, heard and disposed of in the motion stage
Yeah,
itself,
we
my
can.
lord. The small
leave it to your lord.
Heard Jiuddin Learned counsel for petitioners. On request made by Mr. D.K. Sharma, Learned additional senior government. 2 weeks.
my lord.
2 weeks for the time is allowed to file the counter affidavit.
Obliged.
Oblige, yeah.
On 12th January.
My lord, may I pray, my lord, instead of 12, 18 or 19, my lord?
19th.
19.
Oblige, yeah.
Item 2.
Lordship, against the issuance of IMFL warehouse
Lordship,
license.
before my line of senior friend start, lordship, this matter is pertaining to IMFL SOC. Excise council is required, but their name is not reflected in the cause list. Only GA Assam is reflected.
Who? Which council?
Excise department, my lord. It is separate standing council for the excise department. but their name is not reflected in the cause list, my lord. I'm appearing only for the deputy commissioner here, respondent three.
Have you served copy on the
Lordship
extract report?
already, the last occasion they appeared also.
But their name is not reflected in the cause list. Maybe I have missed the case, my lord.
Okay, we'll reflect the name.
My lord,
My lord.
let it be on Wednesday.
Some urgency is there, what?
My lord,
What urgency is there?
my lord, in this case, my
We
lord,
list it in January.
Lordship.
my lord,
We list it in January on the opening day. Registry is directed to reflect the name of the standing council access department in the cost list. And list the matter again on 5th of January.
Deeply obliged,
Alright.
lordship.
item 3,
Hello, in this case, instruction was sought for from the Deputy Commissioner Nagaon.
Yes,
As per direction of the Private Secretary of the Chief Minister, my lord, he was directed to take steps regarding the allegation made by the petitioner.
Hmm.
I have not received the instruction from the Deputy Commissioner Nagaon, my lord. 1 week time may kindly be granted to
okay.
take instruction.
Search Mr.
MH Soikia Lordship.
MH
MH Soikia.
Saiki Alana counsel for the petition. Mr. DK Sharma, additional civil government. Is allowed another 1 week time to receive instructions from the deputy commissioner Nagaon. Based on, when do you want?
My lord, it may also be fixed on 19th of January.
Then you say place for the
2 weeks. my-
2 weeks time. List on 19th.
Okay.
Deeply obliged, Lordship.
item 4,
May I please, Lordship.
Yes,
pass over for the time being, my lord.
why?
My senior is in another court, my lord.
Hmm?
Doubtful. Yeah, really.
No, what? Okay. Hmm. Then it be a PI.
Item 5,
May it please your lordship.
Hmm.
This is a contempt petition, your lordship. There are two judgments of this honorable court, both in favor of the petitioner. First, your lordship, the order at page 9, which is operative part of page 32. I'm showing that because that has been upheld by the division bench. Page 32, the operative part, para 34. Page 32, para 34. In view of the above discussions, the impugn order dated so and so is set aside and quashed. Director of Higher Education, Assam is directed to consider the recommendation of the governing body of Sibsagar Girls College. Once again, consistent with the observations made in this judgment within a period of 1 month from the date of receipt of the certified copy of the order. So that thereafter, your lordship, and a writ appeal was filed by the state of Assam, which was dismissed. The starts from page 33. The your lordship, page 51 is the operative part. 51, last paragraph, 16. In the light of the above discussions, we are of the firm opinion that the judgments dated so and so and so and so impugned in these appeals have been rendered after appreciation of the factual and legal issues raised before the writ court and do not suffer from any infirmity warranting interference in this inter-writ appeals. So, your lordship, the earlier judgment of the honorable single judge for a month period to do the needful have not been done. Now already 3 months have elapsed after the judgment of the honorable division bench. So, your lordship, the contempt is, that is why we have filed the contempt petition. This stage, I pray that your lordship will issue notice on the response.
But why is Manan Lanai counsel for the petition? Issue notice. How many respondents?
3 respondents here.
Petitioner to take steps for service of notice on all the respondents by registered post ID within 1 week.
Yes, Lord.
Please up to 6 weeks.
Much obliged. But
for admission, item 6, 7, and 8.
May it be the lord. Item 6, lordship. I've been very recently engaged.
Hmm.
It may come after the vacation, lordship. Item 6.
6. So if 6 goes, 7 and 8 also will go.
7 and 8 are more or less. Huh? Only 6, lordship.
No, 6 cannot be just separately Where's Mr. Buyan? Buyan and Majumdar.
After vacation.
I don't have it. That's good. All the matters have to be taken up together, my lord.
Oh, that's good. Okay. On request made by Mr.
R.P.
R.P.
Kakuti.
Kakutil and the senior counsel for the petitioner in WBC number 2763 of 2019. After vacation,
After vacation, Lordship.
which vacation? Winter vacation or Bihu?
After being vacation, will be better, Lordship. Because
24th.
Lordship,
Obligement.
deeply obliged.
Item 9,
May I please your lordships? In this case, I am supposed to file affidavit lordship. I sent for vetting lordship, some more time lordship. I am already sent for vetting.
Okay. Your good name, please?
MSY Akhtar.
MSY Akhtar and the counsel for the petition. MSRB Bora and the governor advocate is allowed
1 week time lordship.
another 2 weeks time to file affidavit in opposition.
Deeply.
Restore 10th of January, is it all right?
Deeply.
item 10, 11, and item 30.
Well, item 30, my lord, I file an IA, my lord. IA, my lord, is in writ appeal, my lord, item 10, my lord. In the, sorry, petition I enclosed writ petition, my lord. In this, my lord, the affidavit page was not enclosed at that time, my lord. Miss, my lord. So, my lord, I am be allowed, my lord, to bring this, the page of affidavit and filing a required phrase, my lord.
No, while filing their writ appeal, my lord,
Hmm.
the page of the affidavit filed in the writ petition was not enclosed. So that's why IA has been filed to brought that on record. I don't have any objection on that. The IA, your lordship may allow. Only thing is that there is
Yes.
some pressing need in the matter. If your lordship can kindly take it up immediately after the ensuing winter vacation, that is on 4th,
4th of January, my lord.
4th of January.
In the IA item,
30, my lord.
but Mr. S.K. Mehdi, then it's CGC
Yes, my lord.
for the applicants. By this application, the applicants are praying for filing the affidavit page filed in WBC number 19 of 2023. On the ground that due to any advertence, the same could not be enclosed. In which appeal number?
Writ appeal, my lord, 265, first one, my lord. Item 10.
In writ appeal 265 of 2022. Mr. S. Dutta.
I am for a series of respondents, my lord. In item number 10, all the private respondents.
In the IA,
In the IA same, the array of the parties is same. 1 to 177. 1 to 177.
on behalf of the opposite parties. 1 to
177.
177. Has no objections. Stop. Para. We have considered the course shown in the present IA. And on consideration of the same, the prayer of the applicants are allowed. Stop. In writ appeal number 265 of 2023, you write. And we have the order passed to and so and so. Then it's, you'll have to file an amended one, isn't it?
My lord, you are enclosing that, my lord. Yes, my lord.
You'll have to shall file an amended writ appeal, including the affidavit page
Of the writ petition, my lord.
filed in WBC number 19 of 2022. Within
My lord, 2 days,
within a week from today. Please, this matters On, when do you want?
Fourth of January.
My lord, there is an observation, small observation earlier also, my lord, to not insist the, my lord, the contempt petition as well as the.
That is there, we are not pressing it.
Yes. Highly available.
Obliged.
Item 12 and 13.
With the higher education department.
But after some time, I'll get someone from the higher education. After some time.
My lord. Huh?
After some.
My please, lords. In this case, very small issue, my lord.
Only the case be called out.
Item 14.
Yes.
Very small issue, my lord, relating suspension of the respondent, my lord, private respondent, my lord. My lord, on date of effect of suspension, my lord. Here, my lord, the case is, my lord, he was, the order was passed on first November 2022, my lord. And the said order was communicated to the private respondent on 7/11/2022, my lord. My lord, the requisition was filed, my lord, subsequently it was reviewed, my lord. As for this, the department concerned, my lord, the review is within 90 days, my lord. From the date of effect of the communicated the 7/11/2022, my lord. But the challenge was, my lord, when passing the order of the suspension order, the 1st November 2022, my lord, the 90 days should be counted from that day, my lord. The learned single judge, my lord, when passing the order, this set aside because of that it was not subsequent review was not passed within 90 days, my lord. The judgment is, my lord.
189.
My lord. 189 and 189. 190. 90 relevant portion, my lord, this. I'm coming, my lord, there this. Paragraph 16, my lord, of the judgment, my lord, page 198, my lord. The suspension order is dated 1/11/2020. It is not the case of the respondent that on the said date there was no order or that there were only certain notes in the file. Decision to suspend the petition had acquired the form of an order on 1/11/2022. Therefore, it cannot be said to be that only when the said order suspension is communicated, it become effective. The Honorable Supreme Court in case of Khemiram has made it evidently clear that the case of suspension, it is the date of order from which such suspension suspension would take effect. Supreme Court has also clarified that the matter would be, Supreme Court has also clarified that matter will be defined in case of order pertains to dismissal or removal of employee, in which the case would take effect from the date when such order are received by the delinquent. The Honorable Supreme Court in Municipal so-and-so reported 2007 SCC has further clarified that it is only an order of dismissal from the service when would require to communicate. Paragraph 18, the requirement of timely review of an order of suspension is mandatory one, as has been laid down in the case of Ajay Kumar so-and-so. Paragraph 19. Though the Central Government Council tried to distinguish the case of Deepak Mali Supra by stating that an amendment has been brought to introduce the concept of effective date of suspension. This effective date of suspension in view of the law laid down by the Honorable Supreme Court in Khemira. There is no doubt that the date of suspension itself has to be constituted to be effective date of suspension. It is admitted position that the instant case the review order of suspension was done only 3/2/2023. It is clear that the said review was not done within a mandatory period of 90 days as required under the law. The Supreme Court in case of Deepak Mali has clearly laid down the review done beyond the 90 days would not serve the purpose of law and would have no consequence. In the instance, it is also admitted that no disciplinary proceeding has been initiated by issuing any so-called notice prior to the expiry of 90 days. The aforesaid circular, this court has no other alternative but to hold that impugn order of review 3/2023 is unsustainable in law. Therefore, would not have effective of continuation of suspension order 1/11/2022. Consequently, suspension order so-and-so is status and clause. These are the order passed by.
When was it communicated to him?
7/11, my lord. So for Khemiram is concerned, my lord,
And when did you review?
review was 3rd February 2023, my lord.
Yes.
As per my lord, it is 3rd February with 90 days from 7/11, my lord. But from 1/11, it is not 90 days, my lord. Their case is, my lord, it should be before. So the effective date is, my lord, as per them, my lord, is 1/11/2022. So our, my lord, we communicated them this is on 7/11. So it should be from 7/11 and review order is on within 90 days, my lord. So for Khemiram is concerned, my lord, this Khemiram is concerned, my lord.
Para 17.
Para 17 and 17 is quoted in judgment itself, my lord. I'm reading the para 18, my lord.
17 read it?
Yes, sir. The question when is whether communication of order means it actually received by the concerned government servant. The order of suspension in question was published in Gazette, though it was after the date when the respondent was to retire. But the point was whether it was communicated to him before the date. Ordinary meaning of the word of communication is to impart the confer transparent information. So and so in a as already stated in telegram the 31st July and it August 2nd. 1958 were dispatched to the respondent at the address given by him, where the communication by the government should be dispersed. Both the telegram transmitted or imparted information to the respondent that he was suspended from the service with effect from 2nd August 1958. It may be that the Excel received them in or about the middle of August 1958 after the date of retirement. But how can it be said that the information about his having of suspension was not imparted or transmitted to him on July 31st and August 2nd, 1958. That is before the 4th August 1958, when he would have been retired. It will be seen that in all decisions cited before us was the communication of the imperial order, which was held to be essential and not its actual receipt of officer concerned, and such communication was held to be necessary because till the order is issued, and actually sent out to the person concerned, the authority make such order would be in a position to sense the mind and modify it if it thought fit. But once such order is sent out, it goes out from the control of the authority, and therefore there would be no chance of whatsoever of its sensing of mind or modifying it. In our view, once an order is issued and it is sent to the government servant, it must be held to the government servant. It must be held to have been communicated to him, no matter when he actually received it. And we find it difficult to pursue ourselves to accept the view that it is only from the date of actual receipt by him that order that must be effective. If that would be true meaning of communication, it would be it possible for a government servant to effectively an order avoiding receipt of it by method or other till after the date of retirement, even though such order is passed and dispatched to him before such date. An officer against whom action is sought to be taken thus may go away from the address given by him for service of such orders may be deliberately wrong address, and thus prevent delay of receipt would be able to defeat the service on him. Such matter, just a meaning of the word communication ought not be given unless the provision in question expressly so provided. Actual knowledge by him of an order where it is one of dispersal may perhaps become necessary because the consequence on which the decision of state Punjab and so and so contemplated. But such question would not occur in case of an officer who has proceeded on leave against whom an order suspension is passed, because in his case there is no question of his doing any act or passing any order, and such act or order being challenged as invalid. In 18, in this view, we must hold the order of suspension was validly passed and communication to the respondent before 4th August 1958, therefore effective as from July 31st, 1958. Accordingly, we allow the state appeal and set aside the judgment. So. But this is my lord. Here in the case, my lord is on 31st of July 1958, my lord, it was communicated, my lord. The effect, it was written like this, my lord, the suspension effect will be from 2nd of August, my lord. My lord, in the meantime, the respondent here in that case, my lord, he retired, my lord, on 4th of August 1958, my lord. He received this communication, my lord, on after retirement, my lord. So initially he not joined in departmental proceeding, my lord. On objection, he joined in the departmental proceeding. After, my lord, the departmental proceeding, my lord, against him, my lord, and he filed appeal petition before the Punjab and Haryana court. My lord, my lord, the writ petition was allowed, my lord. Then subsequently, this apex court held, my lord, because of the date of communication, that is 31st July 2058, my lord. Now he communicated. Receive is different, my lord. So this held not 31st July will be the date of communication. So my case before this honorable court, my lord, because we see the order was passed on 1st November 2022, my lord. We communicated him on 7th of November, my lord, 7 November 2022, my lord. And from that, my lord, his suspension allowance was also, my lord, given, my lord. That was he received, my lord. Up to 7, my lord, he worked as a regular employee. So thereafter, after suspension period, my lord, it was count from 7th of November 2022.
The suspension order?
Yes, ma'am.
Page 119. 119.
This is representing against so and so arising out of some illegal obtaining legal gratification which was on depreciation so and so pending. It is further ordered that during the so and so remain enforcement. This effect second therefore the exercise of power on so and so so and so so and so. He is hereby placed under suspension with immediate effect.
Yes.
Well, thereafter, my lord, is what the rules, rule 10 of CCS 1965, my lord.
CCS rule.
CCS rule, my lord. Central Civil Service Class Control and Appeal Rule 1965, my lord. Rule 10, my lord.
We have just one book.
Otherwise, your lordship may find it at page number 34. I have quoted rule 10.6 and 10.7.
34.
34 of the writ appeal.
That's it, page 34, my lord. An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension. My lord, earlier the Deepak Malik case was, my lord, this amendment was not there, my lord. Deepak Malik case was, my lord, I'm reading the Deepak Malik case, my lord.
No, forget about Deepak Mali. What does this rule say?
This rule says from the date of effective date, my lord.
So what does your suspension order say?
My lord, do we file in this regard an affidavit, when the case was pending before the learned single judge, my lord? From the when the date will be effective, my lord? Do we file an affidavit? The date will be effective from 7/11/2023, 2022.
How?
My lord?
How? How will it be effective from 7/11/2022?
My lord, when the query was made, my lord, when the date of effective in this regard.
What does the suspension order say? That
Suspension,
is what we want to know.
suspension is immediate effect, but the communication, my lord, the communication of the communicate, we communicate on 7/11, my lord.
Immediate.
So nothing remains. Yes.
Well, so far, we understand, our understanding is like the minor before this, because when it was communicated to him, because he was not at the station, my lord. He was in the other station, my lord. He was on leave also, my lord. Thereafter, my lord, it was communicated. My lord, it was not handed over to him. It was not communicated, my lord. This FX code Khemiram says the date of communication, my lord. We have communicated, my lord, on the particular date of 7/11.
What does Khemiram say?
Khemiram says, my lord, the order of date of effect of order 2nd of August, my lord. It was communicated on 31st July.
Very wrong. You're wrong. You're putting it.
And my lord, there also discussed one.
Read the second paragraph of para 17.
Before that, the paragraph 14, there is judgment placed before the apex court, my lord. Lordship may bear with some moment, my lord. The first decision to our notice was in Raja Harish Chandra from Raj Singh versus Deputy Land Acquisition Officer so and so. Where the question canvasses was as to what was the date of the award for purpose of Section 18 of Land Acquisition Act 1904. Where it was held that such an award of the collector is not a decision but an offer of compensation on behalf of the government to lender is not effective until it is communicated to him.
There is something different. We're talking about your suspension only.
It is, before, this record is before the lordship, my lord. The fact is, my lord, he was, my lord, the order was passed, my lord, on 1st of November 2022. Again, he has communicated, my lord.
You are arguing against your order. You are arguing against the CCS rules. You are arguing against Kemiram. What is it? Kemiram. Then all your argument is against the settled position of law.
My lord, this was inserted, my lord, amendment by the date, effective date, my lord. So for effective date, my lord, is concerned, my lord. That is to, my lord, this. From 7th, my lord, if it is 7 within 90 days. If not, my lord, then this, from 1st of then we have no case now. This.
That is what we are saying. You have no case. There's nothing wrong with the single judge order.
But Dimokmali says, my lord, this, the only, the 90 days, which was before the amendment, my lord. The 90 days, my lord, but subsequently the date, effective date was, there is a effective date, my lord. Page 34, my lord. Before the 90 days from the effective date of suspension. But earlier it was not inserted, my lord. This, my lord, this subsequent amendment, my lord. Earlier was, my lord, this, like this, my lord. I'm reading, my lord.
When was this amendment made?
Amendment was made in 2007, my lord. Deepak Mali case was 2006, my lord. 2006, my lord.
2007, amendment was done.
Yes, my lord.
When did you pass your order?
We passed on 2022, my lord.
1/11/2022.
Even the amendment also, if your lordship proposes to page number 137. Even the amendment says from the effective date, the language is that one, page number 137.
Effective date, my lord, is just if it is effective date is, my lord, from the issuing the order, then we have no case, my lord. Then communication date, my lord, is 7, my lord.
Page number 137, paragraph number 4. Next page, page number 138 is the most important part here. If I may just read out, your lordship. Consequent upon this amendment, it would henceforth be necessary to specifically indicate in the orders of suspension the effective date of suspension. And the suspension order clearly says with immediate effect.
Yes, Mehdi, any more?
Only, my lord, his suspension allowances from, my lord, 7/11, my lord. Thereafter, he's my lord, as a getting all regularly, my lord. Just everything is from 7/11, my lord. So my, because as he's my lord, getting everything, my lord, before 7, my lord, without effect of the suspension order, my lord. Because the moment, my lord, this effect, my lord, he should have also get, my lord, this allowances from this 1/11, my lord. This is my humble submission, but because, my lord, everything is he's getting suspension from allowances from 7/11, my lord. So he was communicated 7/11, my lord. But in fact, the order was passed 1/11, my lord. And to the effect also, my lord, we clarified the epidemic also, my lord. This now it should be from 7/11. My lord, page, my lord, 129, my lord. 130, my lord, although the suspension order was issued on 1/11/2020, but the same was handed over to the petitioner on 7/11. As such, suspension order will come to the effect from 7/11/2023.
How can you modify your order by an affidavit?
That is true, my lord.
Then
But thing is that Malad, he's getting the suspension allowed from 7-11.
Yes, but
Your lordship, the issue is very simple here. If your lordship peruses to the impugn suspension order, both the suspension order, 111, it is with immediate effect from 1/11/2022. That is not under dispute. The only question under dispute is to do what is the effective date of communication. Now, if we have to go by the judgment pronounced in the Kemiram judgment from dictum of the Honorable Supreme Court, I think the issue is very much clear as to the effective date of communication. Now, here, the effective date of communication is very clearly and secondly expressed in the second paragraph of paragraph number 17, that it is from the date of issuance. My understanding says that it is from date of issuance and it is effective from that particular instance. Now, the 90 days period would start from 1st of November 2022. And as I already mentioned at page number 34, it ended on 29th of January 2023. The second review order was issued on 3rd of February 2023. That is beyond the 90 days period. Now that 90 days period, if your lordship peruses to page number 34, is a mandatory. It reads, shall be reviewed. It is not obligatory or directory, discretionary for that matter, but it is mandatory that they have to review it before the 90 days period. And that is what the Deepak Mali judgment says in 2010. And this amendment, as my learned friend was talking about, it was in 2007. Deepak Mali judgment came later on, 2007. And it clearly says that it's a mandatorily that 90 days period has to be followed. If not, the suspension order becomes invalid on the 91st day. And once that becomes invalid, the second review order automatically becomes invalid.
where's the review order?
It's at page number 121. It's dated 3rd of February. And that too, I have received this particular review order on 12th of February. Now, if we have to go by that analogy, that it is from the date of if even receipt also, then also, if you have to if you have to actually observe their analogy, then also the 90 days period was over.
Where's that amendment 2007?
That amendment, your lordship,
Yeah,
it's at page number 134, 134.
Only 34.
137, I'm sorry, your lordship.
We can close this. And the dictate or, huh? You do it. Okay.
Earlier it was Malad 90 days from the date of order of suspension. Now it is Malad 90 days from the date of effective of suspension.
Are you still serving in the NHIDC here?
No, 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 no. I'm not serving. I've been repatriated way back, long back. Only after I joined, this particular suspension order was issued after a period of 4 years from the alleged complaint. That too, then now the disciplinary proceedings are going on. I won't comment on the merits of that particular disciplinary proceeding because that would prejudice me. But the only question here for determination is, your lordship, is the effective date of suspension.
Okay, heard Mr. S.K. Mehdi, learned counsel, learned CBC for the appellants. Also heard Mr.
D. Bora.
D. Bora, learned counsel, appealing for the respondent number 1 oblique writ petitioner. Stop. Who are the other respondents?
NHIDCL, your lordship.
Anybody appearing?
Mr. R. Talukdar, he appears. Otherwise, they are formal party, they are not a necessary party.
Or the respondent number 1. No, just say. File survey in the National Highways and Infrastructure Development Corporation Limited, within bracket NHIDC, on the petition. No, cancel it, cancel it. There were some allegations in the discharge of the duties of the respondent number one while on the petition in the National Highways and Infrastructure Development Corporation Limited, within bracket NHIDCL in short, on stop. Accordingly, by an order dated 1/11/2022, the issued by the Undersecretary to the Government of India, the no, it's not it. Respondent number one of liquid petitioner was placed under suspension with immediate effect. Stop. Thereafter, comma, the suspension order was reviewed and the by order dated 3rd February 2023, issued by the Deputy Secretary to the Government of India, Ministry of Defense. The suspension order was further continued. The respondent number one, as street petitioner, approached the learned single judge by filing WBC number 1074 of 2023, challenging the order of challenging the order of suspension. You challenged the review order, isn't it?
Yes, your lordship,
Only the review order.
only the review.
Challenged the order dated 3rd February 2023 on the ground that the review was made after 90 days and therefore his suspension period should be set aside. Suspension order should be set aside. Stop. Para. The learned single judge, after hearing the parties, disposed of WBC 1074 of 2023 by an order dated, by a judgment dated 18/10/2023, and the operative portion reads as under. Page 198, para 20, A to A. Para. Being aggrieved with the order dated 18/10/2023, passed by the learned single judge. The appellants are before this court by way of the present record. Stop. Para. It is an undisputed fact that the respondent number one was placed under suspension by order dated 3rd February 2023 with immediate effect. By order dated 1st November 2022 with immediate effect. Stop. Thereafter, the order of review of suspension was passed on 3rd February 2022. Stop. The only question that arises before us is whether the review order was passed after the expiry of 90 days after the issuance of the initial suspension order dated 1st November 2022. Stop. Para. Rule 10 of the Central Civil Services within bracket classification, comma, control and appeal, close bracket, rules 1985 was amended by way of an office memorandum dated 12th July 2007 by inserting by amending by inserting the word where is that
90, 137.
127
137.
by inserting the words 90 days from the effective date of suspension. Stop. In the case of in the case of State of Punjab versus Khemiram, reported in AIR 1970 SC 214, the Honorable Supreme Court has held as under Rule 17 you quote BDB. Stop. Para. Coming to the case in hand, what we have noticed in the first suspension order dated 1st November 2021 is that the suspension would come into effect, would come with immediate effect, i.e. 1st November 2022. Stop. Once an order is issued and the same is communicated to the government servant, comma, we are of the view that it is immaterial when the government servant received the order, particularly the suspension order, and the effective date of such suspension order would be in terms of the suspension order. Stop. In the present case, comma, the order of 1st November 2023 clearly states that it is with immediate effect. Stop. This is in consonance with the amended rules, Rule 10 of the CCS within bracket CCA rules 1965. Stop. We therefore hold that the 90 days for review of the suspension order dated 1st November 2022 would expire with effect from
29 with effect from 1st November 2022.
No, with 30 days will expire from
90 days
yeah, 90 days.
from 1st November 2022.
No.
When is
January,
it
January.
expiring?
29th of January
With
2023.
effect from 29th of January 2022. Stop. Stop. The review of the suspension order was issued only on 3/2/2023. Stop. In that view of the matter, comma, we have no hesitation to hold that the review of the suspension order dated 1st November 2022 was done after the expiry of the 90 days as stipulated under the relevant rules. Stop. Accordingly, we see no merit in the present opinion, and according the same is dismissed.
Highly objected.
Lordship,
Your Lordship, I just have a small prayer. In the single judge order, there is no mention as to when he should be reinstated. And so far, they have not initiated any proceeding as to reinstate.
The appellants are directed to reinstate the response number 1 of liquid petition forthwith.
Highly obliged.
Lordship, I'm appearing on behalf of NHIDCL, Mr. R.K. Talukdar. Kindly record his name.
Mr. R.K. on top is R.K. Talukdar, Learned Standing Council NHIDCL. Appears for the respondents 2 and 3.
Highly obliged. Lordship.
David is there?
Sorry, Your Lordship.
David,
Yes, yes. Caveat is there. Your Lordship.
heard Mr. D. Bora, Learned Council for Deputy David. David is discharged.
Highly obliged.
Item 15.
My lord, there is also caveat here, my lord, that we discharge first. In addition to this.
Who is the caveator?
Deputy council.
Yes, my lord, I am.
You are the caveator.
Yes, my lord. My lord, I am appearing for KP.
Heard Mr.
MK Hussain, Lordship.
M.K. Wilson, Learned Council for Caveator. Caveat stands discharged.
My lord, may I to your lordships, my lord, here facts are almost admitted, my lord. And the question is, my lord, the essence of time prescribed under section 15 of the Panchayat Act, which is the very quintessential element in bringing about no confidence motion against the president or the vice president. Here, whatever, my lord, the admitted fact is that on 14/3, to kindly lordship may note the date, on 14/3/2023, a notice of no confidence was signed by the 10 members of the Panchayat. I am the directly elected president of the Panchayat by direct franchise. And my lord, that was served on the secretary of the Panchayat, my lord, on 17/3/2023.
Notice was issued on
By the secretary, not by me. I am the president on 17/3/2023.
that was served on you.
And then on next day, on 18/3/2023, I was served the notice put up before me. So the effective date of receipt of notice would count, my lord, from the date of service of the notice on the president, against whom the no confidence motion is brought. Then, my lord, 15 days time expires on 1st of April 2023, counting from 18. If a lordship counts from 19, my lord, then it would be 2nd of April. But what the secretary of the Gram Panchayat did, my lord, hurriedly, he referred the matter to the Anchak Panchayat, my lord, on 30th of March, 2 or 3 days before the expiry of the 15 days time prescribed. That is mandatory, held by full bench also. So, and then the Anchak Panchayat sat over it indefinitely. The private respondents came before this court, my lord, in depreciation number one depreciation before this court, and got an order that pending disposal of the depreciation, there is liberty to, if they so think fit, they may go ahead with the no confidence motion. I also came, then no confidence motion was passed, 29/5, you will also kindly note, 29/5/2023. 29/5/2023. But the file was not forwarded by the Anchak Panchayat and the Panchayat Secretary to the Deputy Commissioner. What is the file prescribed law is that after expiry of the 15 days, the Secretary would refer the matter to the Anchak Panchayat within 3 days. If I fail to hold the meeting within 15 days, not 15 days, then within 3 days, the Secretary should refer the matter to Anchak Panchayat. And if the Anchak Panchayat fails to call the meeting, convene the meeting within 7 days thereafter, after receipt of the notice from the GP, then, my lord, the Secretary of the Gram Panchayat has again another role, my lord, to refer the matter to the Deputy Commissioner of the SDO Civil, as the case may be. And the Deputy Commissioners or the SDO Civil shall call the meeting within 7 days thereafter. There is the total period of time prescribed. It all comes to my 35 days. If a lordship is to count starting from 15 days from the date of notice to the end of 7 days before the Deputy Commissioner. But the Anchak Panchayat doesn't forward anywhere, returns the file indefinitely. The Secretary also does not forward to the Deputy Commissioner.
Then, my lord, they passed the resolution on 29/5/2023, removing me. I challenge that. In that, my lord, there is interim protection to me that except financial matters, I shall continue. So I am continuing till that. The tenure of expiry of the my lord, period of 5 years should be on 1st of February 2024. Now counting from this date today, it is exactly 45 days. Today is 15. On after 45 days, the tenure, my tenure and entire tenure of all the panchayats in Assam will expire.
When?
On 1st of February. So my contention is that my lord, for this 1 month and 15 days, why I should be disturbed? I am directly elected. Since they could wait for 4 years, 10 months, 15 days, I could be, there was no reason to disturb the position now for 1 month, 15 days. By the time your lordship's order goes, it will be hardly 1 month, 10 days or 12 days. So that is my condition. So, my lord, I am supported by 2 division bench decisions and 1 full bench decision, my lord, which held that overruling the one judgment of division bench judgment of this court, that the period prescribed under section 15 is mandatory. You have to follow. But what happened, my lord, in the intervening period, this court on 17/5/2023, on their application, writ petition, I have got separate petition, they are the different writ petition, passed the order on 17/5/2023 that they may convene the meeting. So that order I am challenging, my lord. And ultimately meeting was held on 29/5, long after the expiry of the period prescribed through, starting from day 1 to day last. And this court, my lord, by order dated 28/11/2023, I was directed to hold the meeting, my lord, on 13th of December, last gone. But I moved this petition, my lord, before lordship on 12th of December, and the lordship was pleased to grant status quo. And status continuing, and I am continuing.
Who is the order?
My lord, page 137, implement order. That is the case, my lord. Otherwise, there is no dispute, my lord, regarding receipt of the notice putting before me. 137, relevant portion starts, my lord, from 141. 141. 28/11/2023. Facts as narrated here are true in the order, my lord. But that aspect was not considered. Of course, we were taking our, my lord, ground in our writ petition 322/3 of 2023 in paragraph 7. I am agree with the order, my lord, at page 145, paragraph 12. That you made to hold the meeting on 13/12/2023. This meeting cannot be held, my lord. It is already time has lapsed. May I now turn to Panchayat Court? Panchayat. Take all lawsuits to section 15 of the Panchayat Act. Section 15 of Panchayat Act. Time limit the essence of the entire matter.
Section?
Section 15, my lord. Here's your lordship, what, my lord?
Yes.
No conference motion against the president and vice president. Every president or vice president shall be deemed to have vacated his office forthwith when resolution expressing want of confidence in him is passed by a majority of 2/3 of the total number of members of the Gaon Panchayat. That's one part. Now, second part is very important. Such a meeting shall be especially convened by the secretary of the Gaon Panchayat with approval of the president of the Gaon Panchayat. So, effect that is my approval or bring it to my notice. That's what the division bench, both the division bench here held. President. If the such meeting shall be presided over by the president, if the motion is against the vice president and by vice president against the motion is against the president. In case such meeting is not convened within a period of 15 days from the date of receipt of the notice, the secretary of the Gaon Panchayat shall within 3 days refer the matter to the president of the concerned Anchalik Panchayat, who shall convene the meeting within 7 days from the date of receipt of the information from the secretary of the Gaon Panchayat and preside over the meeting. In case the president of the Anchalik Panchayat does not take action as above within the specified period of 7 days time, the concerned Gaon Panchayat secretary shall inform the matter to the deputy commissioner, sub-regional officer, civil, as the case may be, within 3 days after the expiry of the stipulated 7 days time, and the concerned deputy commissioner, HD civil, shall convene the meeting within 7 days from the date of the receipt of the information with intimation to the Jila Parishad and the concerned Panchayat and preside over the meeting. So concerned. So this is the period total prescribed. If it is not held, in fact, here there is no question of deputy commissioner is civil coming to picture because the Anchalik Panchayat failed to convene the meeting within 7 days. The secretary of the Gaon Panchayat did not refer the matter to DC. Matter entered there itself. Having once referred, that too 2 days before the expiry of 15 days, that kills the entire proceeding. And my lord, I am relying on 2 division bench decision, my lord. One is my lord Ali Ahmed Majumdar, 2011 3 GLT 396. Yes. And one is copy code. One is my 2017 5 GLT 829. Here also the date of effective date of receipt of the notice is the contention. Every in 2017, my lord, GLT, the division bench decision of 2011 is been followed. So there are 2 division bench decisions. And so far as whether it is mandatory directly, that was issue in one division case, my lord, the full bench decision after hence held that it is mandatory, not directly. In 2011 December, paragraph 8, 9, 10, and 12 are the important. Here also the secretary defaulted in calling the meeting time, referring the matter in time, and it was held to be illegal, and the no confirmation motion was passed. Paragraph 13. And Malayan second, the minority 2017 5 GLT, following the judgment of 2011 amendments, it was held what would be the effective date of receipt of the notice by the president. When it is brought to the notice or put before him. Here was the date of receipt of the notice. Confusion about the dispute about the date of receipt. On that count, my lord, the impugned judgment of the score, this under single bench must go, my lord. And the no confirmation motion held on 29/5/2020, 23 after about after about 2 months from the prescribed period under section 15 is invalid and illegal, non-est. The 17/5/2023 order passed by the single judge, giving liberty to them to hold the meeting is also, my lord, merges with the final order, and that also goes with the final order passed by the single bench on 28/11/2023. And I am continuing till date, my lord. Since the financial power is protected by this single bench. Am I clear on facts, my lord?
Yes.
My lord, I am appearing for the ward members, lordship. Response number 8 to 16, lordship. 9 in numbers, lord. Lordship, kindly have a look at page 145. Operative part of the impugn order, lordship. Page 145, paragraph 11 and 12, lordship.
Yes.
May I read, lordship? In view of setting aside and quashing the impugned resolution dated 29/5/2023, lordship, as well as office order dated so and so, the petitioner is restored back to the post of president Rampur Satragaon Panchayat with immediate effect. 12 is important, lordship. Be that is at may, this court also cannot be unmindful of the fact that the petitioner admittedly has the notice of the requisition which he received on 18/3/2023. Therefore, this court grants liberty to the petitioner to convene the special meeting for discussing the no confidence motion against the petitioner on or before 13/12/2023. 15 days was granted from the date of impugned order, lordship. It is made clear that further course of action shall be dependent upon the meeting if so convened, and if it is not convened with the time permitted herein, then the law would take its course as per provisions of the act. So as per section 15 of the Assam Panchayat Act, lordship, meeting is to be convened within 15 days from the date of knowledge, lordship. There are several judgments of this division bench of this honorable court. I have 4 judgments which held that these are directory, lordship. And my senior lordship, relying on judgment, that held that mandatory, lordship. Whatever may be, lordship, Lanet Singh Judge, lordship, given the president 15 days from the date of passing of the order, lordship, impugned order, lordship. And if you go through the lordship prayer of the writ appeal, they prayed for setting aside of this impugned order passed by the Lanet Singh Judge. If this impugned order is interfered with, lordship, by setting aside the impugned order, lordship, then automatically no confidence against the petitioner will revive, lordship. Because it was set aside by the Lanet Singh Judge, lordship. In case
Paragraph 12 only.
in case of lordship interfering with the impugned order, lordship, then requisition no confidence motion passed against her will automatically revive, lordship. And more so, lordship, 9
How many respondents are?
lordship 8 to 69 ward members, lordship, I am representing before this honorable court. And there is no time limit prescribed for lordship no confidence requisition, lordship. Only for by-election it is 6 months time. Before expiry of 6 months, by-election cannot be held. But for no confidence, lordship, no such time limit, lordship. Eight to 6.
Is agree only with para 12. No, what happens if the resolution goes? If the resolution goes, then just what members will have to convene, they'll have to give another requisition, isn't it? We take it. Court need not have fixed a date. Is it?
Right. To that part, we can-
Mm.
as per the law.
Yes.
So I may rely on for division bench judgments of
Yeah,
dishonorable.
where is that full bench judgment?
My lord, holding direct, my lord, amending theory, my lord, yes. Para nadu. Here, whatever my lord, this, wall developments held, this is directly. And in paragraph 26, the full bench disagreed. That was referred to the full bench and they disagreed. Paragraph 22.
Even though lordship, if it is assumed that mandatory 15 days was given by this on a single just lordship from the date of passing of order lordship. Order, impending order was passed on 6th.
From the, not from the passing of the order, my lord, from the date of the receipt of the notice. The 2006 1 GLT, page 46, division bench judgment, Mumtaz Jana Askar was held to be was negative. Paragraph 26, my lord. Reading between the lines, it does not transfer to us that the above view rendered by the developments can be construed to denote that the entire scheme of section 15 is the your earlier session feature has been enunciated to be directory and not liquidative. It rather seems to accentuate that each and every departure from the procedure and the time schedule contained therein, however minuscule, would not impair the exercise so as to decisively annihilate the same. In the contextual fact of the case, present case, appeal, the controversy, contraventions already noticed herein above, which we constitute to be sufficient to answer the issues presently raised, would not consider it essential to embark on the scrutiny of these proposition in the instant proceeding. So that judgment was overruled, my lord. The development judgment.
Yes. It's also admitted.
This
We have a lot of work. You want to do it? Okay. No problem. Just say we're interfering with paragraph 12. Yeah, something. Here now confirming requisition, this issue of that 15 days in the requisition.
Right.
So maybe it may not be simple like that. maybe giving liberty to the ward members. To proceed in importance of law, that's in terms of the panchayat. Okay.
May I submit, my lord? I'm appearing for the department, my lord, Panchayat department. Although it's a fight between the elected members, my role is like a amicus curiae in this matter, my lord. So may I read once again the first paragraph of the section 15, my lord?
Hmm.
On the first paragraph, my lord. Assam Panchayat Act, section 15.
Hmm.
May I read, my lord? Yes. Every president or vice president shall be deemed to have vacated his office forthwith when resolution expressing want of confidence in him in passed by a majority of 2/3 of the total number of members of the Gaon Panchayat. Now, Lordship may kindly come to page number 141, my lord, of the appeal, my lord. The judgment, my lord, the impugned judgment, my lord.
Yes.
Yes. The instant writ petition has been filed by the petitioner challenging the resolution dated 29/5/2023. My lord, as per resolution dated 29/5/2023, petitioner was out of the table, my lord. After passing the resolution, 2/3, my lord. That was the subject matter of this, the single judge order, my lord. Now, lordship may kindly see paragraph 9, my lord, 144 is number. By this order, my lord, upon hearing the learned counsel for the parties and taking into account that the period of 15 days was not complied with as per the mandate of section 15 of the Act 94, this court is of the opinion that the said amounts to an infraction of to section 15 of the Act of 1994, and accordingly the impugned resolution of no confidence which was adopted on 29/5/23 is bad in law, for which the same is accordingly set aside. Lordship, I respectfully submit, my lord, that this order was passed on 28/11/23, and by the strength of this order, he revert back to his chair, my lord, to the post of the president. Now, my lord, this appeal has been preferred challenging this order, my lord. If lordship will set aside this order, everything will go, my lord. Because of this strength of this order, my lord, he is sitting in the chair, my lord. So now I'm submitting, my lord, respectfully submitting, because now petitioner want only status quo, not set aside this order.
No.
But main prayer of this writ appeal is to set aside the order.
Yes.
If this order will go, he will go, my lord.
I am on,
So technically, this writ petition is against himself only, my lord.
I am on paragraph 12 only.
But the lordship may see the prayer of the appeal, my lord.
Yes.
Page 14, my lord. Page 14 may be seen, my lord. Not for modification, my lord. Page 14 is the prayer. The impugned judgment and order dated 28/11/23 past instance. Not for modification, my lord. So respondents will be happy if lordship will allow this writ appeal, my lord.
Yes, there's some problem with your prayer.
No, my lord. Prayer, you lord, there is also alternate prayer, my lord. Any order says, lots of make impotent for
That will not help.
Yes.
That will not help.
So, my lord, paragraph 12. After setting aside, this order could not be passed to hold the meeting, because you will also finally see again. Section 15. Provide you.
You can amend your prayer portion first.
The position as it is amended, my lord.
If you want to amend your prayer portion, then that is a different thing. We can give you the liberty to do that.
No, in the prayer portion, my lord, also finally see, because there is one judgment of the amendments. If there is no prayer also, my lord, lordship can pass the order by the Lords of Hansaria that I have not brought, of course. That, my lord, the last portion of the prayer. My lord, so I'll come to that portion. So, the further orders as to a lordship may deem fit and proper in the facts and circumstances. They too will guard me. The lordship deem fit and proper. So I am on paragraph 12 particularly. So since it was in
But you're
the,
challenging the judgment as a whole.
yes, that is true, my lord.
How?
Because the judgment has affected me by virtue of paragraph 12. Otherwise, up to paragraph 11 is all right. Paragraph 11 is in my favor, up to paragraph 11.
But look at your prayer portion. That you have to amend.
Yes. Yes. Yes.
What do you want to do?
Okay, I'll amend it, no doubt. But law point is very clear, madam. Law has it's been decided on this point. Because once a lordship holds that the period of 15 days is mandatory.
That we are not into that law. We're into your prayer portion.
Yes. And some defect in the prayer portion would not, my lord, supersede the provision of section 15.
In fact, in merit also, my lord, I'm submitting on merit, my lord. Already he has given 15 days time, my lord, as per the section 15, my lord. The earlier order interfered in favor of him and 15 days time was given, my lord.
No, that is something which we have to consider.
Yes.
That part.
Yes,
That
my lord.
person had to be decided by lordship.
My lord.
Whether that is a valid law or not.
Para 12.
Yes.
My lord.
Power of the court giving 15 days time.
On merit, I will submit on the next day, my lord, if
Okay, Mr. R.B. Sharma, then a senior counsel. Appealing for the appellants. Praise for.
My lord, immediately after vacation.
Praise for 2 weeks' time to file an appropriate application, praying for amendment of the prayer portion of the present. Praise the Lord. Please begin on. 12th January.
My lord, the position is standing today. Let us come and continue.
Let us go order Pastor Lee to continue.
Habla. Deeply habla.
Timing item 12 and 13.
all right.
Pencils. Pencils. Thirteen.
May I please as your lordships? Well, my lord, on the last occasion, my lordships was to please to call for the records, my lord. My lord, the case projected in the appeal, my lord, is that, my lord, I am an OBC. And my lord, I have two certificate in my position. One by virtue of my mother caste, who belongs from the state of West Bengal. And another belongs from my father, my lord, who belongs from the state of Assam. Pursuant to an advertisement, my lord may be pleased to find the advertisement is at page 67, my lord. Just for a moment, my lord, I beg to draw my lordship's precious attention to the advertisement. Page 67 of the memo of appeal, my lord.
Yes.
My lord, in pursuant to this advertisement, I, as a my lord, candidate concerned with the category of posts earmarked at serial number 4 at page 68, my lord, education, 3 posts. 1 post is unreserved, 1 post reserved for OBC, MOBC, and 1 post reserved for SC. So I belongs to the my lord OBC, MOBC. I, my lord, submitted my application for the post of OBC category, my lord. My lord, what has happened? Initially, my lord, I have to submit fairly before my lordships, my lord. Initially, my lord, while I submitted through online, my lord, if my lord may be pleased to find the how to apply provision has also been provided in the advertisement at page 68, last paragraph, my lord. May I read, my lord, a small paragraph, my lord. How to apply? The soft copy or the application to be sent via email, principal government model college.katc@gmail.com to the principal Pandit Deen Dayal Upadhyay Government Model College, Katlisara, with a subject application for the post of librarian assistant professor in the subject of so and so, and hard copy to be submitted at the time of interview. Contact number so and so. So, my lord, the last date given is at the top of this page, my lord. Applications with the relevant documents along with a demand draft of rupees so and so only drawn in favor of the principal Pandit Deen Dayal so and so College, Katlisara, payable at Hailakandi must reach the undersigned on or before 4 p.m. of, my lord, this is the cutoff date, 26/8/2020. Now, my lord, what has happened when I submitted it as a soft copy via email, my lord? I submitted my lord, mother's caste certificate, my lord, due to some inadvertent mistake or something like that, my lord, as I am not very fully aware that it will not be counted in the state of Assam. Accordingly, my lord, before 26, I submitted this via online, but before 26/8/2020, I submitted my father's caste certificate through offline mode, my lord, before the college authority that this is the certificate I have also in my possession, my lord. So, my lord, accordingly, the college authority accepted my father's caste certificate and proceeded with the selection process, my lord, and I have been allowed and I have been subjected to scrutiny of the documents and found eligible and qualified to participate in the selection process, my lord, and accordingly, interview and call letters were also issued, and I had been asked to appear in the interview. Accordingly, my lord, I appeared in the interview. A detailed selection process had been carried out, and in the merit list, I topped in the merit assessment, my lord. And thereafter, it has been sent to the Director of Higher Education. Once the governing body of the college approved the resolution of the selection committee, that has been transmitted to the Director of Higher Education. That's the mistake lies, my lord. What has happened? The college authorities did not transmit my father's caste certificate. That's why, my lord, the Director of Higher Education, while examined the document and particulars, my lord, found that, my lord, as it has contained my mother's caste certificate from the state of West Bengal, admittedly, which cannot be counted in the state of Assam as a reserved category candidate, my lord. That's why the Director of Higher Education initially rejected the selection process and asked the, my lord, principal of the college to go for a fresh selection. When the principal received the communication, then he realizes his mistake, my lord, and subsequently additional documents were again sent to the principal Director of Higher Education, and Director of Higher Education, after examining all particulars, my lord, found that I am in order. And accordingly, my lord, a detailed process has been carried out. After approval of the government, my lord, my appointment order had been issued. My lord, just for a moment, can find my, my lord, appointment order, my lord, at page 129, my lord.
100?
129, my lord, of this memo of appeal, my lord. My lord, this is the appointment order issued by the Director of Higher Education, my lord, page 129. In exercise of the authority conferred under the provision of Rule 7A of the Assam College Employees Provincialization Rules 2010, and on the basis of the recommendation of the selection committee and the governing body's resolution number so and so dated so and so of the governing body of Pandit Deen Dayal Upadhyay Government Model College, Katlichara, Hailakandi, the following person is hereby appointed as assistant professor with the following terms and conditions mentioned below. My lord, this is the appellant before my lordships, my lord, and this appointment order, my lord, this appointment order had been put into challenge before this honorable court in a writ petition, my lord. My lord may be pleased to find the order of the writ petition, my lord, starts at page 149, my lord. Initially, my lord, in the writ petition, there was an stay order provided, my lord, that the appointment should be kept in abeyance, my lord. And my lord, we moved an application for vacation of the said interim order, and accordingly, this honorable court, the learned single judge, was pleased to dispose of the interlocutory application along with the writ petition, my lord. My lord may be pleased to find the operative part starts at page 150, my lord. 150, my lord. Starts at 100. My lord may be pleased to take up from page 152, my lord. May I read, my lord? The interlocutory application has been filed by the respondent number 7 for modification of the ex parte interim order dated so and so, passed by this court in the connected writ petition. The writ petitioner has put to challenge the appointment of the respondent number 7 as an assistant professor in the Department of Education in the Pandit Deen Dayal Upadhyay Government Model School, Katlisara, in the district of Hailakandi. The genesis of the challenge pertains to the claim of the respondent number 7 belonging to the reserved category of OBC/MOBC. The petitioner has demonstrated that the said respondent number 7 is a permanent resident of the state of West Bengal and has been stated to be belonging to another caste by the appropriate authorities of the state of West Bengal, which is different from the caste declared by the authorities of the state of Assam. Since there is anomaly in the caste of the respondent number 7, the writ petitioner has raised serious issues regarding the appointment offered to her pursuant to the recruitment process initiated by advertisement dated so and so, and this court, by order dated 22/09/2021, while issuing notice, had directed that any appointment given to the respondent number 7 pursuant to the advertisement dated shall not be given effect to until further orders. It is the interim order which has been sought to be modified in the connected IA. Mrs. R. Devi, learned counsel for the respondent number 7, applicant has submitted that even before the interim order was passed, the respondent number 7 was already given the appointment by letter dated 22/9/2021 and had joined in the said post, and therefore the interim order is actually infructuous. On merits, the learned counsel for the respondent number 7 contends that though the proposition advanced on behalf of the petitioner that belonging to an OBC category in a particular state may not automatically confer the same status in another state may be a correct proposition. The facts are totally different in the present case, as the competent authority in the state of Assam has already declared the respondent number 7 to be belonging to OBC, and that certificate is not the subject matter of challenge. My lord, may kindly note, my lord, that my father's caste certificate has not been put into challenge, my lord. Sri so-and-so, the Learned Standing Council, Higher Education Department, Assam, submit that the certificate by which the respondent number 7 has been declared to be belonging to OBC category, not being the subject matter of challenge. The appointment offered to the said respondent number 7 perhaps cannot be challenged in a writ proceeding. He further contends that the issue will involve factual metrics which may not be able to be adjudicated by this court in exercise of its writ jurisdiction against the IA. The writ petitioner has also filed objection. This court has put its anxious consideration to the rival submissions advanced on behalf of the parties and also perused the materials on record from the pleadings and the prayer in the writ petition. Though it appears that the action of making the appointment has been put to challenge, the appointment order has not been mentioned. Though the said action is not found fault with by this court, as the appointment itself is the subject matter of challenge, what intrigues this court is that the basis of the appointment, namely the category in which the appointment of the respondent number 7 has been made, namely OBC, has not been challenged by the writ petitioner in any specific manner. Unless the claim of the respondent number 7 is successfully challenged, the challenge to the appointment only on ground of caste will not be sustainable. Further, this court has noticed that the claim of the respondent number 7 is fortified by a certificate issued by the competent authority of the state of Assam, which has declared the respondent number 7 to be belonging to Jolha caste, which admittedly is an OBC/MOBC category. Though it appears that there is some anomaly with the caste mentioned by the appropriate authorities of the state of West Bengal, vis-a-vis the caste mentioned in the certificate issued by the state of Assam, that will not be the cleansing ground to entertain the present challenge. In view of the above, this court is of the view that the present challenge is devoid of any merit, and accordingly, the writ petition is dismissed. It is, however, made clear that the dismissal of the writ petition shall not stand of the way of the petitioner to make an appropriate challenge to the claim of the respondent number 7 to be belonging to the category of OBC MOBC. It is needless to state that in case of such challenge, the guidelines laid down by the Honorable Supreme Court in the Kumari Madhuri Patil versus the Additional Commissioner's Tribal Development reported in so-and-so shall be adhered to. The writ petition accordingly stand disposed of, interim order stands vacated. So, my lord, the initial writ petition was very much clear, my lord, why it was not been entertained by this honorable court. A detailed reason has been provided. Now, against this order, my lord, it has been assailed in a writ appeal, my lord. And in that writ appeal, my lord may be pleased to find
This order.
this order, my lord. This order has been preferred in a writ appeal number 110 of 2022, my lord. And in the writ appeal, my lord may be pleased to find the order passed. Writ appeal order. Yes, my lord, it is in page number 312, my lord.
Yes.
My lord has got it, my lord. My lord, it is an order dated 22/11/2022. Heard Mr. So-and-so, learned counsel for the appellant, Mr. So-and-so Education Higher Department for the respondent number 1, 2, and 3, and Mr. So-and-so learned senior counsel assisted by Mr. So-and-so, learned counsel for the respondent number 7. During the course of hearing, it is pointed out that the last date consideration of the application was 26/8/2022, whereas the certificate issued by the authorities was pressed into service much after the said due date. My lord, this is a submission made orally before the honorable division bench of this honorable court. Mr. So-and-so, learned counsel for the appellant, contended that the said point was raised. This, my lord, may kindly note that it was a assertion before the division bench that this point of submission of my caste certificate was after the cutoff date was raised in the original writ petition, which has been averred before this honorable court. However, the same was not considered by the learned single judge. In such circumstances, it is open for the appellant to file appropriate application for clarification of the same. The appeal is adjourned to 16/12/2022. So, my lord, the appeal was not disposed of. It was adjourned till so-and-so, and accordingly, my lord, this appellant preferred a review application before the honorable court. Now, before going to the review, my lord, if my lordship permits me, my lord, to bring into the notice of my lordships to the pleadings, which they in the original writ petition was. What was the crux of the original writ petition was, my lord? My lord may be pleased to take up writ petition. But it was a part of the writ appeal itself, my lord. My lord may be pleased to find. My lord, writ petition starts at page 172, my lord. Oh. My lord, the pleading starts, the basic pleadings. My lord may skip up to page 177 and 178. My lord may be pleased to take up from paragraph 4, my lord. May I read, my lord, a relevant paragraph, my lord, that the petitioner states that in response to his application dated 17/8/2022, the college authority under the signature of the principal of so-and-so college Katlisara issued calling letter dated 4/11/2020, wherein informed him the date of interview so and so for the said advertised post of the Department of Education so and so. Copy of the calling letter so and so, my lord. The petitioner stated that the interview was held on the said scheduled date on so and so, wherein the petitioner along with other OBC of the MOBC candidate were. One page appears to be missing, my lord. In this regard, obtain information through Right to Information Act 2005 from the Principal Government Model College, Borkula. That is,
Where are we reading?
my lord, I am reading paragraph, page 180, my lord. Page 180, paragraph, one page appears to be misplaced, my lord. My lord, these are the just factual position they have about, but their main crux starts from, my lord.
You have 179.
My lord, may there is paragraph 20, my lord, page 187. Page 187, my lord.
Yes.
That the petitioner states that the respondent number 7 completed his MA in education from the IGNOU in the year 2017. He completed MA degree in the year 2011-12. Thereafter, he cleared his NET in 2014. Therefore, as the MEd is a professional course, the petitioner cannot be considered for appointment as an assistant professor in the undergraduate college, where for the appointment of assistant professor for the post of assistant professor in education, the basic qualification is MA in education. Therefore, on this ground also, the appointment of respondent number 7 is not sustainable in law, and the same is liable to be set aside oblique quas. Lord, this is the main crux of their writ petition. In the nowhere in the writ petition, my lord, I have read over and time again, my lord, I have not found a single line, my lord, challenging that the my caste certificate from the state of Assam had been pressed into service after the cutoff date of 26/8/2020, my lord. Now, in a writ appeal, my lord, it has been verbally asserted that, my lord, I have submitted my caste certificate after the cutoff date. And therefore, my lord, the division bench of this honorable court on verbal submission has, my lord, given liberty to the petitioner to prefer a review petition, my lord. And that review petition, my lord, may be pleased to find at page 314, my lord. And accordingly, my lord, the entire facts has been averred and the review petition has been projected. And they in the review petition, they have make out a new case, my lord, which is not permissible under the provision of the review of the CPC, my lord, which from my limited knowledge, I respectfully beg to submit, my lord. What they have done, a new case has been projected before the learned single judge. And accordingly, the learned single judge has disposed of the review petition, my lord, by disturbing my appointment on a case, my lord, which was not at all maintainable on the pleadings of the original writ petition, my lord. My lord may be pleased to find the order which we are assailing in this writ appeal starts at page 454, my lord. My lord may skip the few paragraph, my lord. These are factual aspects, my lord, which I have already brought into kind notice, my lord. Page 457, paragraph 12, starting the, my lord, findings of this honorable court, my lord. Paragraph 12, Sri so and so, the learned counsel for the applicant has submitted that, firstly, the respondent number 6 does not belong to a recognized OBC category in the state of Assam. It is submitted that even if it is assumed that the respondent number 6 belongs to the OBC category which is recognized in the state of West Bengal, the same will not automatically mean that such community would be regarded as an OBC in the state of Assam unless the same is notified. Secondly, so and so submit that the stand of the respondent number 6 pertaining to his claim as an OBC is absolutely inconsistent, as in different application, different stands have been taken by the respondent number 6. In this connection, the learned counsel has referred to the application submitted for a similar post in another college in Assam, wherein the respondent number 6 had declared himself as a general category candidate. Thirdly, it is submitted that the advertisement dated 13/8/2020 has stipulated that the applications were to be submitted on or before 26/8/2020. Therefore, even if it is assumed that the respondent number 6 was indeed an OBC category candidate, such certificate was brought to light much after the last date, and for that matter, even after the date of consideration, it is submitted that the Director of Higher Education, while later dated 22/2/2021, as mentioned above, had discarded the OBC certificate of the respondent number 6, which pertains to the state of West Bengal. The director had in fact recommended for re-advertising the post. It is only thereafter when the principal of the said college, while later dated 22/3/2021, had made a reference of the OBC certificate of Assam, and all these facts were revealed only at the stage of the writ appeal in the affidavit filed by the state. In support of his submission, Sri So-and-so has relied upon the following cases, Miller. So now, my lord, all these submissions of both the parties, all the sides were heard, my lord. At page 465, paragraph 30 is, my lord, the finding of this learned single judge, my lord. Paragraph 30 at page 465. The facts of the case in hand, however, do not revolve only on the issue of late submission of the OBC certificate by the respondent number 6, but also the mode and manner of such submission, and also the contemporaneous materials of existence of another OBC certificate of the said respondent number 6 issued by the state of West Bengal. It is not in dispute that while applying for the post as per the advertisement dated 13/8/2020, the respondent number 6 claimed to be an OBC, and in support thereof had furnished a certificate of OBC issued by the state of West Bengal, wherein he was categorized as Kotha Muslim. The Honorable Supreme Court in the case of Bir Singh has laid down that a reserved category candidate of one state cannot be deemed to have similar status in another state. The community of the Kotha Muslim is not declared as an OBC in the state of Assam, and therefore the respondent number 6 could not have been considered as an OBC candidate. This court also cannot overlook the conduct of the respondent number 6 as revealed from his application in the recruitment process of the other colleges, wherein he had declared himself to be the general category candidate. The record also reveals that the Director of Higher Education, while the letter dated 22/2/2021, had indeed discarded the OBC certificate of the respondent number 6, which was issued by the state of West Bengal, and had recommended for re-advertisement of the post. It was only thereafter that the principal of the college, by his reply dated 22/3/2021, had annexed a certificate of OBC of the respondent number 6 issued by the state of Assam. It may be mentioned that in the affidavit in opposition dated 5/5/2022, filed by the Director of Higher Education in so-and-so, while the reply dated 22/3/2021 of the principal was annexed, the letter dated 2021 of the director was not annexed. However, the records in original have been produced, which contains both the letters, the extracts of which are quoted herein below. So, my lord, both the letters has been quoted herein below, my lord. My lord can skip this part. Page 467, paragraph 32, my lord.
So your appointment was set aside.
Yes, my lord. Lastly, my lord, may be pleased to find that in view of the, my lord, the learned single judge, what it has arrived at the last conclusion, my lord, just for a moment. In view of the aforesaid factual position, paragraph 34, my lord, this court may not even require to go to the aspect of late submission of a certificate of eligibility regarding the reservation as in the instant case. There is apparently serious inconsistencies in the case of the respondent number 7, who admittedly has 2 OBC certificates denoting 2 different castes. In view of the aforesaid discussion and the facts and circumstances, this court is of the considered opinion that a case of review has been made out. Accordingly, the judgment and order dated passed by this court in so-and-so, sorry, my lord, stands reviewed. Consequently, the writ petition stands allowed, and the selection and appointment of the respondent number 6 MD so-and-so as an assistant professor in the department of so-and-so college is set aside. The respondents may accordingly take steps for filling up the said post by a fresh process as per law. So, my lord, this judgment has been essayed before this honorable court, my lord, on the grounds, my lord, that regarding the issue of the late submission, although it had been discarded by the learned single judge, that is not an issue to be decided. But the issue to be decided is that, my lord, as I am holding two caste certificates, one from my mother's, because my mother is a permanent resident, my lord, in the state of West Bengal, which I obtained by virtue of my mother's caste. That is admitted, my lord. Secondly, my lord, my father belonged to the state of Assam in the district of Karimganj, my lord. My lord, if my lord may be pleased to peruse the caste certificate of both the state, my lord, just for a moment.
The issue is which caste certificate are you supposed to use?
My lord, now the issue is that, my lord, my father's caste certificate from the state of West Bengal has been taken into account, and I am pressing only on that caste certificate, my lord. And that has been taken into account by the Department of Higher Education, and my appointment is basing on that caste certificate, my lord. My mother caste certificate has never been taken into account, which itself reflects from the appointment order. Just for a moment, if my lord may be pleased to peruse the appointment order, my lord.
That we have seen.
Yes, my lord. So therefore, my lord, the issue of this caste certificate of my father, my lord.
With your father, is it? You don't take the mother certificate.
No, but he submitted that before that last.
It's the whole thing.
Said mother was submitted by self, and then later on, father was submitted, but before that date.
Your father's certificate was, your father's caste certificate.
My lord.
Was submitted when?
Before the cutoff date, my lord. It was on 26, and as per my instruction and the college has, my lord, what they have done, my lord, they have maintained a register in the college. And in that register, my lord, what are the documents I have submitted physically? It is being, till date, it has now been intact. But my lord, what is the problem is that although series of litigations or the several round of litigation coming up, the principal till date has not yet appeared, or the none of the selection body has appeared, my lord, clarifying this issue before this honorable court, my lord, that only the director of higher education has entered appearance, my lord.
You have the records.
That register is very much required, my lord, maintained by the selection committee. And my lord, I have been, my lord, supported by some of the judgment of the Honorable Apex Court also, my lord, that even if I, my lord, assume, just for a moment, my lord, for the sake of argument, that the caste certificate is submitted or being pressed into service after the cutoff date also, my lord, then as a reserved category candidate, my birthly given constitutional right of reservation, my lord, cannot be waived or taken away, my lord. That is the judgment of the Honorable Apex Court, my lord. The full bench judgment, it has been upheld, my lord. Now, my lord, if my lord may be pleased to peruse the records, my lord, then you can be.
I am
resolved.
starting the point where my senior has stopped, lordship. He says that the full bench judgment is covered, lordship. As a birthright, he is entitled the lordship to this your caste. But fact is totally different. The full bench judgment of the Honorable Apex Court is that the particular candidate has filled up the form as a OBC candidate, but lordship, he has not submitted the documents, lordship. Here case is totally different, lordship. Here case is that he submitted a document from the state of West Bengal, lordship, and that particular record was sent to the authority. When authority examined the record, then found that that particular OBC category is not acceptable in the Assam. Accordingly, directorate lordship rejected the recommendation and sent it to the college authority to redo the exercise. But college authority, without doing this, lordship, they have taken a proposal and sent the document against by lordship, incorporating a caste certificate from the state of Assam, lordship. Now, my lord has decided the issue, lordship, whether the certificate which was submitted by the petitioner or by the college authority after rejection of the claim of that particular proposal can be accepted in the eye of law or not, lordship. As per the law laid down by the Honorable Apex Court in October itself, lordship, that particular document cannot be considered as a valid document after the whole game is over, lordship. So Lordship has decide only that particular point. Regarding birthright, that is a different issue. Regarding production of a document is a totally different issue, Lordship. I have the records, Lordship. The record speaks that, Lordship. The candidate, when he has applied the certificate, he has annexed as a OBC candidate certificate from the state of West Bengal, Lordship. That is the point my lord have to decide, and it is a settled legal proposition of the law is that, Lordship, candidate have to submit the documents before the last date or the last date of the submission of the application. In Dibba cases in October 2023, Lordship, Honorable Apex Court decided that particular issue. Regarding EWS category on the UPSC, Lordship, where it says that the particular candidate has the UPSC EWS certificate is there before the cutoff date, but they have not submitted the certificate. Then Honorable Apex Court says that although you have possession the particular document, but you have not submitted that particular document before the cutoff date, so that document cannot be treated as a valid document, Lordship. It is settled legal proposition of the law. Otherwise, record is with me. My lord, if wants to verify the record, my lord may also peruse the records. We have also filed the affidavit. My lord may grant for the affidavit.
What affidavit?
In the appeal, Lordship, we have filed a affidavit, Lordship. Directorate in page 278, Lordship. In read appeal, Lordship, we have filed a affidavit, Lordship.
In this read
No, Lordship. In the earlier round of read appeal, Lordship. Oh, earlier round of read appeal, Lordship, as per Honorable Court's direction, my lord had directed us to.
No. We have to issue notice to the college also. Let us see the.
Lordship,
report.
Lordship.
Yes, my lord.
Otherwise, all the records with me, Lordship.
There the selection committee's resolutions, my lord, as well as the acknowledgement register, my lord. That my lordship may, I am troubling my lordship to call for that record, my lord, respectfully, my lord.
We will go by the records, Lordship, which was supplied.
It is the root of the selection, my lord. That is correct. My learned friend is correct.
Submission for private. I file also appeal. I can say one part. Yes, my lord, I
You
heard.
also filed an appeal.
Yes, my lord, against one part, my lord, no, that is, my lord, the so far, my lord, this press advertisement is concerned, my lord, that part, my lord. And in this case, I'm appealing for private respondent. Here, my lord, I heard, my lord, initially, my friend, my lord, friend submitted the caste certificate, mother caste certificate West Bengal, and father's caste certificate Assam. It is in record. And my lord, finally, my lord, last submitted, my lord, the mother certificate, my lord, Assam, and father certificate West Bengal. My lord, here, my lord, if in my lord, it is recorded, my lord. Initially, so if that my lord, mother certificate is West Bengal and father certificate Assam is initial submission. And when lastly, my lord, he submitted father certificate is West Bengal and mother certificate is Assam. It is in record, my lord. This is in record, my lord. So this is the case, my lord. This where if his case certificate is he stand up the my friend also, my lord, different, my lord. It is record. And my lord, only I want to show this affidavit, the affidavit which is filed in earlier writ appeal, my lord. I'm only reading. I'm reading this letter from the principal. Principal, with reference to the letter under reference on subject, I have the honor to inform that the selected candidate, this writ appellant, so and so submitted his OBC certificate from the state of West Bengal. It is principal's letter. And PRC from Assam earlier at the time of applying for the post. Now he has now it's my lord 2021, my lord. That is before now it was before 2020. Submitted OBC certificate from Assam. My lord, this is complete. This is in the record also, my lord. My appeal it is there, my lord. So the principal himself stated that on 23rd. March 2021, he submitted this letter to director. This Assam certificate is submitted. This is the case, my lord. So this everything in review also, my lord. The record is done.
That we'll see.
And no stay, my lord, because my lord.
Not here, Boyan and we'll admit it. Admit. Mr. Gogoi, यहाँ पे K. Gogoi, Standing Council, Higher Education. appears for the respondents, 1, 2, 3. One twenty. And Mr. SK Medi.
For respondent of 7, my lord.
No, concern appears for respondent of 7. You have to take steps.
My lord, by registered post, my
Then
lord,
to
the
take
all
steps
private,
for
my lord,
service of
as well as Dusty may also be permitted.
on the respondent 4, 5, and 6. By registered proceeding in 1 week from the sub. Additionally, petitioner is also, appellant is also permitted to cause service of notice on respondents 4, 5, and 6 by
Well.
justice service to the registrar of this court within a period of 1 week.
Well,
1 week from today. Thereafter, appellant shall file an affidavit to that appellant.
my lord, some interim protection.
no, my lord.
Kindly- My lord, why I am
No, my lord.
submitting, my lord? My lord, till date, my lord, I have not been disturbed by the college authorities, my lord. And in that event, my lord, status quo as on date at least may be maintained, my lord. I have a prima facie case, my lord, that's why, my lord.
No, my lord, that is not. my lord.
Status quo, my
Because
lord,
it will
no, my
affect,
lord,
my
my
lord.
learned friend is objecting on interim prayer, my lord. How he is going to be affected, my lord, that is
Because,
required to
because
be
my lord,
ascertained.
my lord is.
He has not been appointed, my lord.
My
I
lord-
have been appointed
My
and
lord,
working
this
for
is-
last
my lord, this.
2.5 years, my lord.
What you suggest?
The record shows that he has not given the other certificate on time. That's what Gugoi had said. I leave it to you.
No. If you allow him, he will continue. No?
He'll continue.
This after 4 weeks.
My lord, some interim, my lord.
No interim.
Well,
My lord, so far my case is concerned, my lord, there is another writ appeal, my lord. There is notice me which.
402.
What is this?
No, 407.
407. Only death part, my lord.
But this came a deal that counts for the appellant. Admit. Appellant, Mr. K. Google and standing on higher education affairs for 1, 2, 3. And Mr. Brian, you appeal?
my lord, I am for the respondent number 6, my lord.
Respondent
number 6.
Appellant to take steps for service of notice
My
on
lord.
respondents 4, 5, and 6.
4, 5, and 7.
My lord, what is the, my lord, difficulty is that there is a direction of the learned single just to go for a fresh selection, my lord. As my lordship is examining, my lord, that part may be kept in abeyance, my lord. Till the examination is done by my lord, my
No,
lord.
I
If
don't
the
know.
fresh advertisement is given, then third party right will come into, pressed into service, my lord. My lord, may you please to take up the impugn order alone. The last part, my lord, is at page 468. May accordingly take steps for filling up the said post by a fresh process as well.
In the first case, 402. In the interim, it is directed that the respondents shall not take steps for filling up the post
My lord.
of
The assistant professor in the Department of Education, Pandit Deen Dayal
for
Upadhyay
filling up the
College.
post of assistant professor in the Department of Education.
My lord, Department of
In
Education.
the
Pandit Deen Dayal Upadhyay College, my lord.
in the
Well, it's same in my petition.
One will suffice.
Well, that might, because sometime after it will difficult. Same prayer in prayer. That's part, my lord.
in the Pandit Deen Dayal Upadhyay Government Model College, correct? Katli Chira, district of Karimganj.
District of Hailakandi, no?
Same prayer in my petition.
Malad, in the district of Hailakandi.
This Hailakandi.
Katlichara is in Hailakandi.
Is it?
My-
It's in Karimganj here.
No, no, Lord, this is maybe
Hailakandi.
Hailakandi.
Yeah, Hailakandi.
My
Same order in the other.
obliged, madam, highly obliged.
Pending item 4.
May please, your lordship. My lord, here in this case, my lord, the petitioner essentially praying for amendment of the Foreign Tribunals Order 1964. My lord, the contention of the petitioner is that, my lord, the 1964 order is a procedural law for conducting, my lord, FT cases for the citizenship status, my lord. But there are serious defect insufficiency in the order. The clause 3, my lord, of the Foreign Tribunal Order 1964 mentioned about the notice to be served with main grounds. But what is main grounds? That has not been explained. And my lord, if we presume that main grounds means grounds of doubt about citizenship, how that materials is to be collected, my lord? There is no whisper at all in the Foreign Tribunal Order 1964, my lord. How the investigation is to be carried out, how the, my lord, what will be the basis of, my lord, of the investigation, the manner of investigation, nothing whisper at all in the Foreign Tribunal Order 1964. Lordship, if lordship wants to, my lord, have a look at, my lord, the clause 3, may I read out, my lord? The tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be foreigner, give him a reasonable opportunity of making representation and producing evidence in support of the case. After considering and such evidence, he may be produced after hearing the such person as may be desired to be heard. My lord,
Who are you?
my lord, I am one of the, my lord, conscious citizen, my lord, social activist, my lord.
No details are given, lordship.
No, I have given.
He is only given his educational qualification.
My lord, in fact, my lord, the petitioner approached the Supreme Court, my lord, and filed a PIL, my lord, before the Supreme Court, and that case has been closed with an observation that the petitioner should approach this honorable court first. That order is also, lordship, I have annexed in
Nothing
page
wrong with the Supreme Court.
75.
Here he has to satisfy.
Page 75. my lord. Petitioner would be at liberty to move the High Court for seeking approval. So accordingly, my lord, we approach this honorable court, my lord. And page 75.
The only paragraph where he divulges about himself is paragraph number 2 and paragraph number 5. Everybody is conscious. Lordship.
Can it be a PIL? Can it be a PIL?
My lord.
Can your grounds be a PIL for
Yes.
consideration on the PIL?
Yes, my lord, the huge number of people, poor people, my lord, vernacular section of people are suffering, my lord. Lordship, may have a look at the some documents I have annexed.
I have serious objection, lordship. Who are vernacular people? We do not have any English persons out here. So far as the citizenship of this country is concerned, we know Hindi, we know the language of the state. What more vernacular do they need?
My lord, vernacular, I mean, my lord, the poor people. Poor, my lord, have not. They are doubted. They are doubted without any basis, without conducting, my lord, fair investigation, my lord. May I am.
Either it is ill drafted or he does not know.
My lord.
Vernacular is not poor.
My lord. My lord, my lord, I am relying on the two judgment. One of.
Forget the judgment. You have to satisfy us.
Yes, my lord. The judgment, my lord, in Sarvananda Sunwal 2 case, paragraph 60, the Honorable Supreme Court has said that the onus of the collect the to materials of doubt is the initial onus on the state. My lord, that has never we have seen the the state has fairly discharged the burden to collect materials of doubt. My lord. And in paragraph 97 of the full bench judgment of this honorable court, there has been a guideline of carrying out the investigation, which and observed that there cannot be fair trial without fair investigation. And what is fair investigation? That has been also been explained. My lord, the suspected person should be given an opportunity to demonstrate that he is not foreigner by producing his relevant documents at the stage of investigation. And he is to be asked in presence of, he should be interrogated in presence of the elderly person of the locality. His statement is to be recorded, his signature is to be collected. My lord, we have seen, my lord, huge records, my lord. In many cases, my lord, this procedure is not followed. Some examples we can show, my lord, and some records we have produced.
Lordship,
my lord.
if I may respond to my friend Lordship. If I may respond to my friend. Lordship.
1 minute. You first show your locus. That's
My
what we're asking. Who
My
are
lord.
you?
My lord, I am a social activist, my lord. I am a conscious citizen of Assam, my lord. Being a permanent resident of Tezpur, my lord, I have stated in paragraph 5 and 2 also.
You ask him. There's no problem.
Any social works that you have done, any environments that you have made? What social works earlier you have done?
He has published so many books.
Where
He is
have you
publisher of
said
so
all
many
that?
books.
Paragraph 5, Lordship, he says
My
he has
lord.
published a few books. No details. There are no details there. It is just one line that you have said.
My lord,
If you are a social, as you are contending that you are a socially aware citizen and all.
my lord, he is
activities
aware.
have you done?
He is aware. He is, my lord, he has conducted, my lord, awareness program during the NRC process, my lord. If your
Mr.
lordship
what-
requires, I will file an additional video
What we're
detailing.
saying is that there's nothing in this PIL. There's nothing describing who you are.
My lord. My lord, this question has not been raised in the by the Supreme Court in the
Maybe
PI.
not, maybe not.
My lord,
But in the High Court, the question is being raised.
my lord, I may be given a liberty to give a details, my lord, by way of additional affidavit, if lordship, my lord. I will file an additional affidavit detailing the all backgrounds, my lord.
Mr.
About
Ayer,
social
accept that
status.
the counsel for the petitioner is permitted to file an additional affidavit. List after 2 weeks.
Development.
Item 18 for orders.
May I please, Lord? I appeal on behalf of user Soikia. He's going to pick his daughter from school. So let the matter pass over for the time being.
Hello, in this case, we have filed our affidavit.
The ground floor.
Time at 2 Lord.
Let us all go to the school then.
Lord.
What are we doing here? Let us go to the school.
I'm lost in this.
Is that the way to address the court?
Lord.
You want an adjournment, we can adjourn your matter.
We have filed our affidavit, my lord. In fact, we are ready to, my lord, argue, but up to your lordship, my lord.
Our request is made on behalf of the Cycle and counsel for the petition. This on 11th December, January.
But that may be after, my lord, Bihu vacation.
24th.
All right.
19.
There is an application filed by me for vacating the interim order, my lord. That may be heard personally.
Look, this is a matter where this is regarding. There is already a decision that entire matter will be heard. They filed an IA, my lord, for modification of the interim order, and this honorable court decided that we will hear the entire matter. Lord, what happened in this matter? This is with regard to transfer of the appellant, my lord. He was transferred just.
My lord, my IA may be taken up. IA number, my lord, 3234 of 2023.
He was transferred just 10 months before his retirement, saying that public service.
Have you filed your affidavit?
My lord, I have also filed the.
In terms of that order, 8/11/2023. 8/11/2023.
Yes.
Order.
2311 they have filed, my lord. And
In the IA.
in the IA.
In the writ appeal, they have filed the affidavit.
You filed in the main writ.
Yes, ma'am.
Para 5, para 6 and para 8.
And my IA, my lord, may be taken as an affidavit, my lord, and it may be heard. Whatever, my lord, here, I was transferred to Longding, my lord, from Itanagar as Longding division.
My lord, I have filed an reply to the affidavit in opposition filed by the state of Arunachal Pradesh. Perhaps that is not in the records of the before your lordship. That's why the matter has come for orders, my lord.
I have a copy, my lord. I will hand over that copy. Given to me. My lord, here what may be on the facts, my lord.
No, here you file your IA for vacation of the interim order.
Yes, that is should be taken first. Here what, my lord, I was
Are you
transferred.
willing to file are you filing objection in this IA or not?
My lord, I have filed a reply against the affidavit in opposition. Yes, my lord. Yes. I need an opportunity.
Is causing me serious loss. I've already
Look,
joined
may-
in the place. Just a minute. Joined in the place I was transferred. He is not. He has not released. I took united charge as per the government notification. I'm there, but my pay is held up. I'm already in the position where I was transferred, my lord, and he was transferred back to because in view of his impending retirement, as per the government circular, my lord, he should be general. He should be transferred to the head office. So you are transferred to head office in compliance there too. Of course, it is not before 1 year.
Mr. Sharma, but then the issue is he has a right to file an objection.
My lord?
He has the right to file an objection.
But
So
he
we
should have
can-
filed one. Time is delayed. I am suffering.
We can give him a short time.
Let him file more. Because he has already filed the affidavit in government. So someone
the
cover
problem-
loss
my lord,
or let him repeat it in my application, my lord. So because every day delay is causing me serious.
my lord, the
injury.
problem is,
My my children are suffering, my lord. They are not in position to go to school, my lord. I am financially handicapped now. And my lord, what is right? Your lordship knows the Shilpi Bose case, 1991. That is being followed throughout. There is no statutory violation. Unless there is statutory violation, my lord, he can prove. Then only he can sell the transfer order.
Yes, thus,
Based on the, my lord,
when are you filing your affidavit?
my lord, lordship will give me some time because he is from Arunachal Pradesh, Longding district, my lord. It's far away, my lord. At least a week's time, my lord. Immediately on
then
the
my lord, the
reopening,
vacation will start.
immediately in the reopening, my lord will fix the matter, my lord.
You will list it on third.
Third.
Yes,
Fine, my lord. Fine.
in the IA. Third, Mr. R.B. Sharma, senior counsel. Assisted by?
Yes, being here.
Yes,
Yes, being here.
Behenge, learned counsel for the applicant. Stop. Mr. H.K. Das, learned counsel, appealing for respondent.
My lord, appellant, my lord, writ appellant.
Readable.
Who did it appealing here?
Lordship is taking up the IA or writ appeal, my lord.
IA.
Lordship will, yes, my lord. I'm just placing respondent number perhaps 1. No, my lord, respondent number 3. 3, my lord, in the IA.
Hagi Tachang.
No, my lord.
My client.
Page 4, my lord. Hageta Chang, that is the cost title of the writ petition.
No, this is.
Page 4 of the IA, your lordship will find it. Respondent.
Which IA?
3, 2, 3, 4.
3, 4. In fact, this I was filed in October. October gone, November gone, December gone, my lord. You should have filed it by this time, knowing it is very important.
IA number
And
three
at
two
least for
three.
me,
Oh, this is not a fresh IA.
right?
No, why have you not?
Milord, what I am trying to, Milord, submit before your lordships is that this IA was filed, thereafter, the government has filed the affidavit in opposition, Milord.
Yes.
This IA was filed in the backdrop saying that he was not given posting and salary.
No, posting is there. I've gone immediately, not that.
Milord, if my senior allows me to, Milord, then I can place the facts before your lordship. Milord, he said he come up with an objection that he was not paid salary and posting. Then this honorable court was pleased to pass an order dated 8/11/2023. My lord will kindly have directing the Arunachal Pradesh that you justify why he has not been given posting after the transfer order was stayed by this honorable court.
That is what I was asking Mr. P. Goswami.
Yes. And they clarified that he has been paid salary.
He has been adjusted but temporarily in view of the tendency of the case only.
So there is no embargo that he has not been paid salary. He has been posted and he has been paid salary also.
No, no, not yet paid.
No, is he being paid?
No, not yet.
His
Though
salary
there is
has
an order,
been
my
paid.
lord.
No, their affidavit says he has been paid.
Yes, no, not yet paid.
He has been paid from.
There is an order, my lord. Yesterday
And-
also I got the instruction. There is not, he has not been paid yet.
To be fair enough, my lord, my submission is that he should be paid. Yes. Page 93, running page of the affidavit.
They have annexed one order, my lord.
Page 93, madam.
And it is dated 12th of October 2023. I am hanging there.
I am directed to request you to allow.
No hanging, my lord.
The pay and allowance in respect of Haggadah. Executive engineer from the overall strength of your establishment with respect from the month of September 23, the clearance of the court system for taking charge of logging period of the, so that logging period, it is then manner only in view of the pendency of the
Please.
litigation.
I am there in Longding.
That was in October.
Fine.
Yes.
So what does the chief engineer do? Sir, what is the reply of the chief engineer? Is he paying the salary or not?
No, nothing.
This is the instruction, madam, on withdrawal of monthly pay and allowance.
That is fine. That you have given the letter.
Yes.
Yes.
But is he being paid or not?
By this too, it appears he is being paid, madam.
No,
How can we say he has been paid?
no idea, no?
To allow the withdrawal of monthly pay and allowance with respect to the Haggadah. This is from the government, my lord, the chief engineer. I can, your lordship wants, my lord, for fighting takes it, I can fix it.
Yes, you better take the
But
instruction.
actually, I think this is being compliant. I don't know, my
No.
senior friend.
If he's not being paid, that's why he's saying that he's not being paid.
My lord, he may have some problem.
So let the chief engineer clarify whether the payment is being made to him, salary is being paid to him.
That's good. On the part of my payment of salary, my lord, can it be done? The rest, it will come on third month.
By
Okay.
Wednesday, my lord, or Friday.
Yes. Can it be fixed
No,
on?
no, Friday will be difficult.
No, can it be fixed on
Lordship will
21st?
take up the entire.
Only about the telephone, he will take the instruction. If not paid, he will pay. At least let him not suffer, my lord.
Then we'll
Then
take
also-
up at 2 o'clock. You talk on the phone.
Yes, yes.
My lord.
Okay.
Yeah, meantime, I'll give you.
My lord, lordship, fine.
There's no point.
No, I also don't want that he remain, my lord, in hanging, my lord. He should be paid his salary.
Item
Highly
20.
My lord, I'll be bit out for some urgent. 1 minute to tell you medical, my lord. Can it be tomorrow, my lord? Kindly,
Okay.
tomorrow.
List these matters. Again, I'll give tomorrow's. Tomorrow's. 19th.
Deeply. Lord, there was an interim order passed in this matter, my lord. Interim order.
Interim order passed will continue. Till the next.
Deeply.
Till tomorrow.
Item 20.
May it please your lordship. Madam, this IA is by the respondent number 6.
but the matter relates to a private market by the name of Goronagar Damri Bhasha Bridge Tinaliye Cattle Market. It is that cattle market and the writ petitioner is against us for running the cattle market. But the cattle market was established in 2013. Your Lordship please to see the order dated as to how it was established. And page 19 of the IA
May please, Your
and
Lordship.
24 of the IA.
Before my senior started his argument, Lordship. In the IA, morning also I pray for some time to file objection, Lordship. In the meantime, I have served the objection copy to applicant side.
Have you filed your objection?
Lordship, already served.
No, have you filed?
Today itself we will file.
Then let him file here.
But the objection will not be required possibly because of the reason.
Whatever it is, he has a right to file an objection.
Yes. He has a right to file an objection.
So let
An
it
objection, but it will not be that necessary in the sense that the new amendment has come in the Panchayat Act 107. That new amendment has come into force with effect from 19th October 2023. Last night I could see it. Therefore, this application may be disposed of, saying, but initially there was no embargo on the running of a private market in the private land of the persons concerned. And 107 was declared null and void by this honorable court in Rupam Taludar's case. And that was our stand before this court. And that was, we filed it, their application, that our market was stalled. Running of the market was stalled by the Deputy Commissioner. Now, because as on today, 107 has been amended, saying that no private ghats or fisheries shall be allowed to operate with the area of the jurisdiction of a Gaon Panchayat without the prior approval of the concerned Panchayat authorities and the government. That amendment, originally it was there, originally it was in the language, the powers of settlement of private ghats and ghats and fisheries will be under the jurisdiction of the Gaon Panchayat, shall be vested in the steering committee of the Gaon Panchayat. That was there. That was set aside and declared void by this honorable court in division bench in Rupam Talukdar case, 1989. But now, this amendment has come into force, saying that the private house also will require an approval.
Mr. Brisidas, let him file his objection, then we'll consider your. Not Mr. Brisidas, the senior counsel assisted by Mr. Diego. The counsel for the petition, for the applicants. Mr.
Easy Hazarika.
Easy Hazarika. Then it's counsel appearing for?
Appearing for the writ petitioner.
Writ petitioner.
Opposite party one.
Opposite party one.
Opposite.
Appearing for the opposite party number one. Praise for how much time?
No, they filed.
Their filed copy is given to us
Okay.
today.
Let the matter will come after vacation, let's say.
Praise for us.
Copy.
A week's
Oh,
time
right.
to file objection. Where is allowed? List the matter. Fifth. Fifth of January.
21.
Hey. Danny.
Well, there's a condonation application. Well, similar matters have been condoned and the appeal has been admitted. Basically, we have assailed an order of the single judge where in spite of a substantive appointment, through a summary procedure, we were removed from our service. So our main contention was that we were government servant, the 311 was never complied. In fact, this is the order.
Who are appearing for the other side?
My lord, I think health department is there.
All official respondents?
My lord. All officials.
So 31 days we can come.
My lord.
Heard Mr. D.K. Das, Learned Counsel for the applicant. Also heard Mr. B. Gogoi, Learned Standing Counsel, Health
Health.
Department, for all the respondents.
All the respondents.
For all the respondents. So, by this application, the applicants are praying for condonation of 31 days delay in filing the connected writ appeal. Stop. The explanation for the delay is given at para
4.
Para 4 present application, and we are satisfied. Accordingly, delay of 31 days in filing the connected writ appeal is allowed. Please condone. Stop. Registry is directed to.
My lord, if lordship may, with the lordship's leave, since the appeal has been admitted and it has been fixed in the month of February, the issues are same.
No.
It will have to be number 3.
It's not that
Yes,
number.
lordship.
Item 22.
Well, the I is for condonation of.
How many days?
So this is 160, 169 days.
So notice.
Notice.
D not.
But it will,
D not. Who is the applicant?
the state is the applicant.
Learned Senior Government Advocate for the applicants. Issue notice.
To the OP number 1, or the others are performer respondent. No? To the OP number 1 will fix.
Issue notice to the opposite party number 1. Applicant to.
But Lordship may direct us to take that by dusting. No? Already the connected appeal is already the delay has been condoned. It is, we have mentioned. No?
Applicant is permitted to cause service of notice on the opposite party number 1 by justice service to the registry of this court within a period of 1 week.
1.
Stop. Draft applicants will find an applicant to that effect. This after 2 weeks.
Lordship. Look, the item number 23, 24, 25.
26, 25.
23, 24 and 26 are similar. No? We have condonation petition.
23,
23, 24 and 26.
not 25.
Not 25.
Same order will do.
Same order will do. No?
OP1.
OP number 1.
Same order.
The day of delay is different. Otherwise, same.
I have not mentioned the delay.
Lordship. We will take dusty in all the cases.
Department. This is an application for continuation of 398 days delay in filing the connected writ appeal. Stop. Issue notice. The applicants to take steps for service of notice on the respondent number 1,
Yes, Lordship.
2, 3 and 4.
2, 3 and 4.
No personal
No,
department.
Lordship, 1. Lordship. Only the opposite party number 1. Primary respondent.
Cancel that. Just say issue notice. MS NB Bora, Learned Government Advocate, appears for respondents.
Lordship 2, my lord.
2, Mission Director,
No, lord. Mission Director.
SSA,
No, lordship, the education department standing counsel. Education department.
no, SSA has a different standing council, I think.
Yes, yes. It's under education department. SSA are mission director.
2 and 3.
No, two more.
3.
Yeah, I can appear.
Two members again.
Which one?
I can respondent 3.
B. Gogoi, Learned Standing Council,
SSA.
SSA, appears for respondent number 3. How about secondary education?
But if the
SMT 61.
name can be recorded. Is present, Arthur. He's present.
SMD Chistia, Learned Standing Council, School Education for respond number. Applicant to take steps for service of notice on the respond number 1 by registered post AD within 1 week. Which Dr. Forbes.
Lordship, GA Assembly reflected in the cause list.
Registration is directed to reflect the name of the learned and government advocates in the cost list.
And copy may be served to us also.
What should we?
Item 27 and 28 from supplementary list for orders.
Your Lordship, that is what we prayed on our last hearing, that we want a stay in this newly formed transgender welfare board, because there was no any due process which was followed by the officials.
What is the process?
There is no any process. That is why we are wanting this court to intervene in this matter. Because ultimately this will create a chaos between the community.
In the PIL, can you file an IA like this?
Because there should be a fair, just and reasonable exercise that must be taken care of by the government. That is why we are wanting.
Stay of the notification?
Yes.
On what grounds? That the process was not followed?
That there was no any equitable process was followed. There is nothing is on record till date. Even if your Lordship will see, even for the various other constitutional posts, there is an exercise which are required to be followed by the government or by the election commission, for an example. But what is the process that has been adopted here for choosing the members directly to the welfare?
Supposing we stay this odd notification, it will have an adverse effect on your members.
No. It will
Why
not have any
Why not?
adverse member.
Why not?
Your Lordship may stay this notification, directing the state government to formulate rules.
So till the rules are framed, let them continue.
But how we can allow some members who we don't even think to be a community members will be sitting up there in the welfare board and will be running or then will be exercising the welfare board, your Lordship. That is what creates the
Have you
chaos.
verified? Have you verified?
We have verified, Lordship. We have
They
verified.
have verified what more is required?
Verified,
This is the
verified on
notification.
what ground, your Lordship? Nothing materials they have placed on record.
This is the notification issued by the, on behalf of.
Only
the governor of
notification.
Assam, Lordship. Lordship, I would like to place the earlier notification by which my learned friend has been appointed, Lordship. This is the earlier notification, and Lordship may kindly peruse page 32 of the recent affidavit, Lordship. Lordship, in page 32, the notification, may I read, Lordship?
Of the IA?
Lordship. That is the affidavit we have filed, Lordship. Affidavit in opposition filed by respondent number 4, Lordship. May I read, Lordship?
Yes.
This is notification dated Dispur, August 1st August 2023, number ESGAED so and so in pursuance of section 7.3.3 of the Assam State Policy for Transgenders in continuation of notification number so and so dated 4/5/20 and consequent upon completion of the tenure of non-official members incorporated by notification number so and so, the Governor of Assam is pleased to incorporate the following members of transgender community in the Transgender Welfare Board. So and so now members are being incorporated. Lordship, now if your Lordship comes to the earlier notification, which was issued on 17 June 2020, that is the notification which I have given just now, Lordship. That is number so and so. In continuation of these departments, earlier notification number so and so, dated so and so, the following members of the transgender community are incorporated in the Transgender Welfare Board. This is the same notification number by which my learned
train had earlier been incorporated. Now
Now,
they have
Your
come,
Lordship.
now they have come with a statement that this notification has to be stayed. Lordship, earlier they were mum. They were mum.
If
The
they were-
reason,
if
the reason based on to
we
them,
were
why they
silent?
were
Because there was
silent.
the community members representation. But now there we see no
Why you,
community
why you
members
were silent is
representation.
because you were there, isn't it?
Now your
Lordship,
now your
Lordship.
lordship, for the time being, if we take into account page number 32, that they are community members. But what are the materials available with the other side to place on record that they are the community members to the various provisions, satisfying provisions of section 4, 5, 6, and 7 of the Transgender Act? Your lordship may see once the Transgender Act.
Until and unless they are being made
Because that will
party,
clarify.
Lordship.
Your lordship, once
Until
your
and unless
lordship
they
goes
were being
through-
made party, Lordship, how can these members may come into this IA, Lordship?
Mr. Das, where can we find this section 7.33 of the Assam State Policy?
Lordship.
It is in the PIA.
It's in the PIA, Lordship.
Page?
Page 31 of the main PIA.
I don't think there's anything wrong with this.
And this interlocutory application is also non-maintainable, Lordship.
Now your lordship may also see chapter 3 of the Transgender Act.
Where's the deck?
Because
Chapter 3, number 4, section 4, if your lordships may permit me to read. Recognition of identity. If for the time being, if we take these members as a trans also, but are they satisfying the condition as per the mandate of this act? Section 4 says, recognition of identity of transgender person. A transgender person shall have a right to be recognized as such in accordance with the provision of this act. A person recognized as transgender under subsection 1 shall have a right to self-perceived gender identity. 5. Application for certificate of identity. A transgender person may make an application to the district magistrate for issuing a certificate of identity as a transgender person in such form and manner and accompanied with such documents as may be prescribed. Provide that in the case of a minor child, such application shall be made by a parent or guardian of such children. Number 6, section 6, issue of certificate of identity. The district magistrate shall issue to the applicant under section 5 a certificate of identity as transgender persons after following such procedure and in such form and manner within such time as may be prescribed, indicating the gender of such person as transgender. The gender of the transgender person shall be recorded in all official documents in accordance with certificate issued under subsection 1. Subsection 3. A certificate issued to a person under subsection 1 shall confer rights and be a proof of recognition of his identity as a transgender person. That is required to be satisfied. And until and unless they come up with such materials, we can't term them to be a transgender person.
See,
Section
what
7.
they have done, they've gone through everything.
But what is there on record, your lordship? They are just stating on a piece of paper that is the last page of their affidavit saying.
This is not a piece of paper, this is an affidavit.
Your lordship, at page 40, they are saying that they have so and so foundation, they are associated, they are founder of so and so association. But where is the registration number? What is the foundation details?
No, I don't think. There's nothing. Earlier, her name was John. Yeah, that's the only thing.
Now, your lordship, just merely putting up in markups and putting up a sari done doesn't make anyone a transgender or doesn't make anyone under gender
What you're
incongruent.
saying is correct.
Hmm.
But they've gone through the process.
Now, if your
They've gone
lordship,
through the process and
No.
7.33.
but no other process was
How it is
followed.
to be done.
No one, not a single process was followed because your lordship, if we take into account the process has been followed and duly complied with, what kind of process we don't know. Even if the previous members board has come to a dissolution, now your lordship may just see this page 31 of the PIL. The last page, page 32. Page 32 of the main PIL, the last point, your lordship may just see. Remuneration, traveling and daily allowances as admissible and finalized by the Social Welfare Department will be paid to the non-official members for attending the meeting of the Transgender Welfare Board. Now, whether the previous member was subjected to any payment till date, nothing on record. Your lordship, first, at a first instant, this transgender was categorized scientifically as gender dysphoria. Later on in the normal English usage, it was termed as gender identity disorder. Later on at ICD-11 meeting, which was conducted by World Health Organization, there, this gender identity disorder was removed from the list of disorder. Later on, it came to be known as gender incongruence. So gender incongruence has only 59 categories, transgender categories. But this kind of persons, we can't even categorize in nowhere under the various categories of the transgender, until and unless the process that are required to be followed as per the mandate of the Transgender Act. Moreover, your lordship, you'll
See, counsel, look at your prayer in the IA.
that is why we are
Look at
saying,
your
your
prayer in the IA.
lordship,
There's a new course of action. There's a new course of action.
but even though your lordship, that is a new cause of action, the Supreme Court in many instances has said and elaborated the ambit of the PIL.
From what we get, it appears you have some personal interest in this matter.
No, not personal interest.
There is-
What we have is the
Let us
associate.
be very frank.
No, your lordship, I'm happy your lordship has expressed that. But your lordship, the association has tirelessly working for the community members.
That we understand.
What we want is there should be a fair process. We are not against who is getting elected, who is getting selected. Nothing is our
Fine
matter.
enough, affidavit, how the process, how you have done the selection.
Yes, let them come up with a detailed affidavit.
Lordship, we will file the affidavit, Lordship, as per your Lordship direction, Lordship.
Huh.
But Lordship, if your Lordship considers the main PIL, the prayer in the PIL and the prayer in the IA is something different. That
That's
is the
what we
new,
have said.
that is the new cause of action.
The PIL,
regarding
in the
this,
main PIL, we said there should be an official function, official office for the Transgender Welfare Board.
That has
Now, your
that has already
lordship-
been allotted.
Now, your lordship, when
has
there
already
is
been
no such office, in the meanwhile, government is coming up and formulating committee after committee,
No.
but without paying any kind of remuneration, salary, pay and allowances. Just a form, they are formulating the committee, but there is no any functions as per the mandate of the Transgender Act. So that is nothing but a toothless. Because ultimately, at the end of the day, why we are here before this court and why this court is adjudicating to serve the main cause of the entire community at large. If at the end of the day, if we are getting nothing,
See, counsel, this court is not against your community, not against your member.
no, your lordship, I
No,
haven't said.
No, you have not said, we are saying
Yes.
it. What we are interested in is for the welfare of your community.
Yes.
Correct. Now, the government is doing something as per your own policy.
Lordship.
Now, you're questioning that policy. You're questioning the method in which they have done the issued the notification.
Now in that case, your
Earlier,
lordship,
earlier notification was also done the same way.
Same way.
There was no question on that notification. Why was it?
your lordship, the first notification was based on the advisory committee's recommendation. But this committees was formed without any recommendation.
No,
Nothing.
nothing is written in the earlier notification
We don't
regarding the
even-
advisory committee or something like that.
Let them file a detailed
Lordship,
affidavit.
that is
We
before
will
your
also
lordship
come up,
only, lordship.
we also come
The
up
earlier
with our
notification is
affidavit in
before your-
reply, placing what was the recommendation
The
of the
earlier
advisory
notification
committee.
is before your lordship only. Today I have placed the earlier
Now-
notification.
Now your lordship,
Nothing is there about the advisory
now your
committee.
lordship, the query which
Every time
your
my
lordship
learned
has
friend will
put
come with a
forward.
new cause of action.
That is again chapter 4, the welfare measure by the government. Your lordship may just see once again section 8 of this act. The section 8 says obligation of appropriate government. The appropriate government shall take steps to secure full and effective participation of transgender person and their inclusion in society. The appropriate government shall take such welfare measures as may be prescribed to protect the rights and interests of the transgender person and facilitate their access to welfare schemes framed by that government. The appropriate government shall formulate welfare schemes and programs which are transgender sensitive, non-stigmatizing and non-discriminatory. The appropriate government shall take steps for rescue, protection and rehabilitation of transgender person to address the needs of such persons. The appropriate government shall take appropriate measures to promote and protect the rights of transgender person to participate in culture and recreational activities. Then obligations of establishment, section 9, 10, 11, 12. Then again, chapter 4, the educational, social security and health of the transgender. So these are elaborated rights that are required to be taken care of by the government.
Okay.
It also includes the policies.
For the applicants. in the eye. Stop, Mr. Aramdas. Leonard.
Standing Council,
Standing
Social Justice
Council,
and
Social
Empowerment.
Justice and
And Empowerment.
Department. Shall find a detailed affidavit with regard to the process in which the non-official members
Lordship,
of the TWB
Yes.
were
yes.
selected.
Lordship, may I just pray one thing? Lordship, if your lordship considers the prayer which my learned friend made in the
You file your
PI,
affidavit, after that we'll pass up.
and the prayer in the IA is something different, lordship.
That
That
we've
is,
already-
that is the, her waste, means that is the vested interest, lordship. Personal interest.
We have already hinted the learned council.
Lordship,
You can take that objection in your affidavit.
lordship. Definitely.
Now your lordship,
How long do you want?
Immediately after vacation. lordship.
Okay.
your lordship, there is another aspect in this PIL, at PIL 2. The another thing was,
Affidavit come first.
no, your lordship, that is pertains to the IA. The other aspect of this PIL was that police report. Based the affidavit which they have filed.
Lordship, in this matter, my senior Dinat is appearing. He's on legs, Lordship. Lordship, this matter may be hard to get immediately after the vacation.
Yes, on 5th we are listing it.
Lordship.
Then
Deeply obliged, madam.
the next PIL is PIL 6.
All this will be heard on 5th.
Lordship. Lordship.
Item 29.
My pleasure, Lordship. So this is a IA, my lord, seeking twofold prayers, my lord, seeking leave to demolish the structures of the opposite party and to proceed with the construction of a highway which is halted, my lord, since 1904 to 2023, my lord.
1904.
04. April, my lord, April of this year, my lord, has been halted, and it pertains to my lord that Difu Dimapur Road, my lords. And my lords, the foundation of this petition is my lord, writ appeal number 375, which has been disposed of, my lord. So, well, in that order, my lords, my lord, kindly come to the directly to the order. Page 43, my lord. 43 it starts, my lord. The main body is at 47. 47. Oh, no, 47. No. 42, my lord. 42. 42. The NHIDCL had approached this honorable court being aggrieved by order passed by a learned arbitrator who had stayed demolition, my lords, of a structure of the parties, my lord. So, my lord, in that petition, my lords, the opposite party just sought a IA which was also rejected. Then they sought a writ appeal, preferred a writ appeal, my lord, which was which was disposed of in direction contained in page number 43 of the petition, my lord. Page 43. Well, see that a copy of this order be provided a competent authority in CPWD within 2 days, whereupon the CPWD shall appoint a suitable date for the valuation of the property within the next 5 days, and the valuation.
You are reading from which page?
Page 43, my lord.
Ah,
43, my lord, see, it starts with a copy of this order.
okay, okay.
Yes, ma'am. So, my lord, this order was passed in 28/9. And based on this direction of the honorable court, my lords, the writ petition, my lord, was closed. It started page 44. And that operative portion, my lord, is 48. Solely on the directions passed in, my lord, writ appeal, my lord, this writ petition was closed. That, my lord, CPWD will conduct a verification exercise wherein, my lord, the opposite parties and other authorities would be present, and, my lord, the measurement would be taken. So, my lord, immediately after that, my lord, at page 49, my lords, we wrote to there were twofold directions to income tax. At page 49, my lord, income tax authorities were moved. Annexure H, Poly 1, my lord. To conduct assessment as per the order dated 28/9. And also to admit, my lord, that page 50, CPW does move. That you, High Court has passed an order, you comply with that, conduct a valuation exercise and submit to the arbitrator. To the communication of, my lord, the applicants at page 51, income tax replies on 6/10/23.
One minute.
They replies, my lord, they are not mandated for such work. Thus, since the direction is to the CPWD must proceed. So, my lord, lordship is gone.
One minute.
My lord. Yes, my lords, on the very next page, at page 52, my lords, my lords, this CPWD replies through a mail that on 19/10 will be available for an on-site measurement and valuation in compliance of the order passed by Honorable High Court, my lords. After that, my lord, on 19, my lord, there was everything, a measurement was done. Measurements were recorded in books. At page 53, my lord, they reply. So they, my lord, they are asking for a year of, my lord, will kindly peruse that year of construction of various structures marked with drawing or spells are not still provided, my lord. This is with the competent authority under the Highways Act, my lord. Again, my lords, this at page 54, though they are not a party, but technically because there was no direction against this authority, this is the Kala or the Joint Secretary of the Revenue Department, Karbi Anglong, my lord, that you come and comply, provide the CPW the information they are sought for, and submit a report to the arbitrator. So, my lord, at page 55, my lord, see this executive engineer of the CPWD was again moved. And, my lord, that letter reflects, my lord, at point number 2, that it is intimated the joint verification and measurement of the petitioner structure was done in the presence of representative of NHIDCL on 19th October 2023, my lord.
Yes.
So now the hindrance we face, my lord, since I has already pointed out, my lord, in compliance with the order passed the writ appeal, my lord, measurement has been already taken, books have been recorded, everything is recorded, my lord. So, my lord, my humble prayer before this court is, my lord, to grant us leave to proceed with the construction work, my lord, because there are structures standing of the opposite parties, my lord.
My lord, I am for the landlords, my lord. I am on the opposite party 1, 2, 3, and 4, my lord. We have preferred the writ appeal, my lord. So in that writ appeal, my lord, the Karbi Anglong Autonomous Council, competent authority, my lord, was made arraigned as a party, my lord. But here in this case, there is an apparent defect, my lord, in the IA, my lord. They have not arraigned complaint authority as a party, my lord. They have only arraigned the landlord as a party. Direction by this honorable court, my lord, at page 43 was that ad interim stay, the second last paragraph of that order at page 43 is very relevant, my lord. The ad interim stay order passed by the arbitrator shall stand vacated after valuation report is prepared and presented in the arbitration proceeding, my lord. My lord, this case is basically in relation to an arbitral proceeding, my lord. Direction has been given by the, my lord, arbitrator to an expert to assess and measure and give the report. That was not done by them, my lord. And after that, my lord, since they are want to, my lord, vacate the stay order because of the evolution, my lord, of the law commission, my lord, of the government, my lord, there was no arbitration proceeding, my lord. So, my lord, thereafter this writ petition was filed, my lord. So when we have moved this honorable court, the court, my lord, has directed for measurement, my lord. So measurement was accordingly on 19th, then they have come. But there is no whisper, my lord, about the what is the measurement done, my lord. Nothing, because they are also not aware about the measurement, my lord. Report has to be there, my lord, because the court directed, my lord, that valuation shall be carried out in terms of the order dated 2/5 passed by the arbitrator in the by this honorable court, my lord. But there is no report, and they have not arranged the Karbi Anglong Autonomous Council as a party, competent authority as a party. So that defect has to be cured, and they have to be remain present in the court. In their presence to be done, because my arbitration is basically against them, my lord. Because they have given the less amount, my lord.
So, my lord, we are at
So let them
present, my
let
lord,
them hearing.
considering the gravity, my lord, since the construction has been stalled, my lord, since last, my lord, April, my lord. And my lords, I am
Order has
before
to be
this
complied
court,
with,
my lord,
we are
to modify or modify the order of a court, my lord, court wherein, my lord, that there was no direction against the Kala, my lords.
He's a
43, my lord. Is 42 and 43. Is there any whisper about this, my lord? The authority is pointing out. We are not disputing, my lord. He may be entitled to 100% of whatever he asks, my lord. But as of now, my lords, as I indicated, report has already been taken, my lord. But it's a no other issue that it has not been submitted, my lord. Let the arbitration proceeding go on, my lords. But let us proceed with the work.
But unless and until the report being submitted, my lord. Let them arrange, my lord.
The valuation report is prepared.
Yes, my lord, it's prepared, my lord.
But not annex. He is not aware
No,
of
no,
the
no.
report.
It is with the CPWD, my lord. That is the reason why I have annexed them as a performer parties, my lord.
Then let them come. Let them
Yes,
come with the
notice.
valuation report.
Yes, let them come with a valuation report, my lord. We want that, my lord.
Have you served copies?
Notices to go. I think, my
No,
lord.
I had served copies, my lord.
And my lord,
This union has to come and the CPWD. I'll serve them extra copies, my lord, by tomorrow. If not served.
then the competent authority may be made as a party, my lord. Even my lordship may see the, my lord,
Let us first see the valuation report.
my lord, my lord.
What, Mr.
D. Gogoi, my lord.
Gogoi, Leonard, Standing Council,
For the NHIDCL, my lord.
NHIDCL. Standing Council.
For the moment, my lord.
Okay. So, the applicant to serve copies on the pro forma opposite parties 5 and 6 within the course of the day.
Yes, my lord.
Within the
Will
course.
furnish.
List the matter again on third.
Second, my lord, Thursday can it be taken up, my lord? Because, my lord, season is there. If it rains again, my lord, stall for last April, my lord. And because of there's an overbridge to be constructed, it has stalled some other parts also.
That day also they'll have to produce the valuation report.
Yes, my lord.
So we don't know whether they can produce it.
At least there will be an attempt on, my lord. When they can produce, they can come and say.
21st December.
Obliged, my lord.
Obliged.
You will not be able to receive the money, my lord.
Yeah, state.
Worship, in fact, the compensation is to be paid by the union.
But you have difficulty because of the name.
Yes, Worship, and there is another aspect of the matter which is not highlighted in the earlier order. Worship, where do I pay? If it can be paid in the registry of this honorable court, that may be. Because I cannot identify the petitioner.
The affidavit is filed by the deputy commissioner. Who has filed it? District commissioner.
No, that's the deputy commissioner, district commissioner,
So who represents?
state. Public. I guess
Assam.
What about Arunachal? Anything to submit?
Nothing, Lord. No, the thing is that the incident occurred in our.
Do you not have any system of the Gambura identifying what is the name?
That can also be done, Malad, the Gambura. That can also be done, Malad. Gambura. you can-
Where's the state council?
Well, Uh, if I may take your lordship to page 20.
Of the IA?
Well, this is the affidavit, lordship. The last sentence. I think, connected. Last. This is, I suppose, given by the police, it's not very clear here. The last sentence. I have also collected the local Gambura Pradhan certificate. That maybe should have been enclosed. Yes, sir.
That would be state. He is already filed. They can find out from the district. Is the correct name. That's the problem.
Alternatively, lordship, can I make a prayer? Lordship, let the amount be deposited in the court in the name of the registrar general.
Want to wash your hands off?
No, that after identification, they can issue the check because,
Do we identify?
because if we have to issue the check, then it will be in individual name, then that will again take some time.
Problem is the registry has to identify now after you.
No,
deposit
after
it,
the
yeah.
report comes.
So there will be some problem. Why not you liaise with the deputy commissioner and then identify the person?
We cannot identify, lordship.
Not you.
The deputy commissioner, if the deputy commissioner certifies that he is the same person, Hitami and Himoni, or whatever, sir.
Himoni.
Then
Because this affidavit says the same, like, though it's not in distinct words.
Himodi.
MOD.
And the other one is Hitami.
Hitami.
Hitami and MOD.
I saw. Tomorrow.
Yes, Dhar, your affidavit is a bit wishy-washy.
Yeah, clear. Compensation. To amount to certification of second. There might be a. Yeah, that was going to take it. There won't be a pattern.
My lord, I think we'll have to file a clarificatory affidavit in this matter. What I just.
If you come to page 20,
My lord,
last line,
my lord.
the OC has stated he has collected some Gaupura certificate. Make your inquiries and find out.
My lord. I have also collected the local government Pradhan certificate and came to know the relationship with the petitioner and this was mother and son. Okay. But so we'll have to do some fact finding, my lord. So my lord, post let this matter may come after the vacation. In the meantime, whatever to be done will do.
Just said the petitioner is suffering. No compensation, nothing. Dry. Okay, heard Mr.
M. Smith.
M. Smith, Leonard Counsel for the applicant. Mr. R. Dar Leonard, Additional Senior Government Advocate. Praise for how much time? 1 week, 2 weeks?
2 weeks, man.
2 weeks time
After vacation, man.
to file a clarificatory affidavit. Stop. List on. Give a date after 2 weeks.
19.
That day, if you can file.
I will file a status report, man.
Just say that these are the two same persons.
Same person.
Verified. The certificate is Gamba certificate is here.
My lord.
Because OC has collected the
My lord.
certificate. So you can contact the OC, file it.
My lord.
Then we'll finish it.
My lord, we'll direct the SP is a superior officer to look into the thing and file a report. That will be much better.